Yes.
May it be the Lord. My Lord, it is a mention matter, my Lord. It is second appeal of regular second appeal, my Lord. It is second round of the second appeal. Suit of 1997. And it is pending under Order 41, Rule 11.
Oh.
You might.
Whenever you like,
May it be from 9.
you are the respondent.
I am for the response.
That is fine. Yeah. Okay, bring it on when? After the election?
9th March.
19th. Why? Why on a Thursday? We'll have it on 10th.
May I mention item 47, the review petition if your lordship recalls.
Oh, that
On this
one.
line.
Upgraded. Okay, we'll just take it after the motion. Motions and admissions are over. So I don't have much. Oh, a lot of admissions. Oh, these are not. Oh, not much. Okay. Immediately after item 18, we'll take it.
Okay.
Item number 58, my lord. I have on behalf of the card Council of Deputies.
50.
My lord, matter of fact, actually going for the day of it.
Why?
My lord, because of casting our vote, my lord.
What?
To be, my lord. For casting our vote, my lord. Prepared to be.
Who?
R.
R. Ahmed.
R.
Who is R. Chaudhary? R. Chaudhary is there. Don't worry. R. Ahmed moved the matter.
Sorry, my
Who moved the matter?
R.
Then where is R. Chaudhary?
He's out of.
Okay. The request of the request of the Learned Council appearing on behalf of the petitioner, matters 27 to be listed again on 10th. 10th. Yes. Interim order passed earlier shall continue. Hearing? No hearing.
On 9th of
Hearing? No. Sorry. Hearing, you take it up with the read.
May it please this matter. With regard to item number 56,
Ah.
I have instruction to withdraw the matter.
The A. Iqbal, the Learned Council appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant matter. Accordingly, the instant petition stands closed on withdrawal. The interim order dated
Interim order dated by Lord 26/8/22.
stands vacated. There was a stay to the proceeding.
26/8. Stay to the proceeding by order dated 26.
The interim order dated so and so stands vacated. And the Learned Council appearing on behalf of the petitioner is directed to produce a copy of the instant order before the Learned Trial Court on 10/5/2024. The Learned Trial Court thereupon shall proceed with the disposal of the suit in the manner provided under law.
Another matter, my lord, list for listing matter on Wednesday.
Okay.
If you-
Wednesday not possible because you
Friday.
see now Friday.
Friday.
May I please the lordship? I take for taking one IA in MFA lordship for modification of the on budget.
My order
No, lord.
will have it on 10.
No, item 54, my lord, was never specifically admitted, my lord. Can it be treated as the same matter? The landlord tenant is
There's not yet been admitted.
not in.
Well, we'll pick it up after that matter of Mr. the Muzumdar's matter.
Lordship, I beg to mention two MSC appeals. Lordship, one pending 6/2018 and the other 2016. So for the one, IA has been filed and for the other, additional affidavit has been filed long before. So may come up on 17th May. If Lordship, if it is so.
Okay.
Lord.
17.
My Lord, in item number 12, my Lord, I am filing.
Not for hearing. Are you one?
Item number 12, my Lord, I am filing an IA for vacating of the stay order.
What vacating?
There is a status quo order.
Huh?
There is a status quo order.
The number?
12. Can it be taken up on
How?
Friday? Yes, on Friday or next Monday.
Why do you need it? We'll dispose of the file today. You want to file it thereafter, after disposal if you want. These files are not to remain. Yes, next.
Much of. I mean,
Okay, fantastic.
I prefer listing of motion matter on Wednesday matter. It was filed on 29th of
Not Wednesday, Friday.
district of Yadupet Ayub. Last it was posted on 19th.
Okay, we'll have it on 15th May.
Senior won't be available if it's possible.
Huh?
This week. Senior won't be available if it's possible this week. Your lordship.
You want to do it today?
No, lordship.
Then-
9.
Don't make this type of mistake.
Then lordship. 16.
Can't be a thing. You want the matter to be listed, this court can't fix it. 10th, I have already given so many matters. Then how do you expect it? Then the next day, the opening is on 13th. You may not like the date. We'll have it on 15th.
Yes, your lordship. Supplementary 65 has been wrongly listed before your lord. That should be
Supplementary 60.
5.
What has happened?
Wrongly listed before your lord.
Why?
There has to be an SK Medis. There's some. It has to be an SK Medis for the
SK?
SK Medis.
65.
Yeah.
Whose court?
SK Medis.
Why?
There was some error in the order. There was some error in the order.
Oh, you want for correction?
Yes.
It has been submitted by the learned counsel appearing on behalf of the applicant that the interlocutory application so far is an application seeking correction of the order passed by Honorable Mr. Justice S.K. Medhi. So, taking into account the above, the registry is directed to list the matter before the appropriate.
9 or 10 days can be.
What?
9 or 10 days.
I'm not going to fix anything. You go. I've asked them. You take it up with the registry.
Of like that.
Corporation item number 6.
Yes, what it is.
applied for. See, link has been applied.
Yes, the link. Yes, tell me what is the case. Are you challenging?
The thing will be joining to DC Manor.
Understood, but tell me what is the case.
Couple of-
DC link has been given. What are you challenging?
But in this case, the appeal order has been passed followed under Order 1 Rule 10. That we have challenged.
Why?
1.5.
Why?
I'm led by him.
Where is he?
It has been said. It was applied for.
Somebody wants to strike off their name.
Yes.
You are the plaintiff.
So in this case, my lord, yes.
You are the plaintiff.
No, the person who applied for striking off, they want to strike off their own.
Yes, Mr. Singh.
My lord,
I can only see your forehead. Nothing more than that. Yes. Mr. Singh, can you hear me? You are muted, I suppose. Do you see Mr. Singh? Except his
I can also see only for
prosperous forehead.
or the matter may be taken up on Wednesday, my lord, personally.
At the request of the learned counsel for the petitioner, matter stands adjourned to be listed again on Wednesday. Very difficult, you see.
Or
Friday.
next Monday,
Friday.
Friday, he will not be available.
What is this matter about?
That regarding that.
You don't know.
No, I know, my lord. but
Then
the thing
tell me, what is the matter about?
is, the matter is,
Who are you first?
I am the defendant.
What business do you have if the plaintiff wants to withdraw?
Plaintiff wants to withdraw himself
Ah.
and induct another party. That fellow did not that legal point. Let
Plaintiff wants to withdraw himself.
himself.
And?
His name should be struck off, and the name of another person.
How can that be
Yes,
possible?
that is what has been done.
Then let's see. What is that application? Show me that.
Just on Wednesday, madam. Wednesday or next Monday.
Not when.
The next Monday.
At the request of the learned counsel for the petitioner, matters then adjourned to be listed again on Monday, 13th.
Good.
Supplementary item 60.
Yes, what is this transfer from where to where? You have made a correction.
From Family Court, Kamrup Metro to
Why?
to Dibrugarh.
Why?
But the petitioner is suffering from cancer, man.
Who?
Petitioner. Petitioner is the wife.
Ah.
I
And
have
when
been-
was this filed?
Correct.
Hmm?
But I have annexed the document. That's at page 21 on part.
Page?
21 medical document. Page 20.
Heard Mr. A.K. Gupta, the learned counsel appearing on behalf of the petitioner. This is an application under section 24 of the Code of Civil Procedure 1908 for transfer, seeking transfer of FC Civil, case number 235/2024 from the court of the learned principal judge, family court number 2, Kamrup Metro at Guwahati to the court of the learned district judge, Dibrugarh, Assam. Issue notice making it returnable on 19th of June 2024. Steps be taken by way of registered as well as usual. The petitioner is further directed to take effect steps by way of trustee routed to the registry of this court and file an affidavit of service on or before the next day. This court, having taken into account the contents of the transfer application and the difficulties so expressed on account of the medical ailment of the petitioner, is of the opinion that this is a fit case for stay of the further proceeding of
25.
FC Civil case number 235/2024 till the next stage.
Okay.
61.
Yes.
Wait, is it not?
Any more mistakes? No. Less.
This is a
What is this matter about?
in this case, I have filed the title suit for specific performance. And there is a third party notice. Third party has filed an application on order 110 and that has been allowed. What is the ground for allowing this?
Who is he?
She is the sister of the respondent.
Huh?
She is the sister of the defendant.
Why?
I have entered into an agreement for taking a top on rent. Now, the owner of the land, that land is undivided property. Now, and the third party is the sister of the defendant, who is also one of the legal heirs. So basically, the third party is a legal heir of the.
Show me your plane.
Page number 29.
29. Okay. For specific performance.
Defendant Faizul Islam. I have entered into an agreement. Dr. Kindly see the page number 26 first.
Yes. There's a suit pending between the sister and the brother.
Correct.
Now tomorrow, if you get a specific performance out there and you execute the decree, what will happen to that suit?
Lordship, that should have the fate of the suit be decided. What is the share? Now, share will not affect my right over the agreement which has been entered into.
Kindly see this.
Lordship, I'm just
Kindly come to page 49.
Sure.
That the property mentioned above is the joint property of the heirs of Louis so-and-so and no formal partition is yet effected among them. The heirs of so-and-so are possessing the property in Ismaili that the defendant number 1 tried to construct the building over the land mentioned above without effecting formal partition. So the applicant was compelled to file a suit claiming 1/4 share and there is a status quo as regards the property.
No, Lordship, that has been mentioned in the plain document.
Huh.
That has been mentioned in the plain document. That is why, Lordship, I wanted to rely on the annexed 2, Lordship. The Borders Act started because of this annexed 2. After I have entered into agreement, after I have paid the due amount, Lordship, this notice has come. On behalf of so and so, I do hereby inform that for the purpose of my client's rented premises situated at so and so, you have paid an amount of 10 lakhs by check number so and so in accordance with the agreement arrived at on so and so. However, prior to deposit the check by my sister, the sister of my client, I have obtained an injunction order from the learned Munshi.
Anyway,
on
we do one thing. We issue notice and stay the proceeding.
Right.
That's why. Let's hear the other side.
Right.
Okay. But Mr. T. Dekar, the learned counsel appearing on behalf of the petition. This is an application under Article 227 of the Constitution, challenging the order dated 8/4/2024, passed in midday case number 87 of 2023, in connection with title suit number 82 of 2020. 20, na?
20.
Whereby the learned trial court, by the impugned order, had impleaded the respondent number 1 as a defendant in the state suit. It is the case of the petitioner herein that the suit so filed by the petitioner as plaintiff is in respect to specific performance of a deed of shop agreement dated, what is the date?
8/9/2020.
8/9/2020.
2020. 2020.
2020. And as such, the third party has no, and as such, the respondent number 1 herein, who is a third party to the state agreement, has no business to be included as a defendant in the state suit. So issue notice making it returnable by 19th of June 2024. Steps be taken by way of registered as well as usual. In addition to that, within 3 days. In addition to that, the petitioner is directed to effect service by way of the steel routed through the registry of the school and file an affidavit on service on or before the next. This court, having taken into account the material put forth and the ground which have been taken in the instant application, is of the opinion that further proceedings of title suit number so and so is required to be stayed pending disposal of the instant petition, inasmuch as the order dated, inasmuch as the legality and validity of the order dated 8/4/2024, of the impugned order dated 8/4/2024 is being taken up, is to be decided by the court. Full stop. In addition to that, permitting the suit to proceed at this stage would amount to an abuse of the process of the court. Accordingly, the title suit number 12 state
Highly object.
pending before the
7 and 8 already.
At the outset, my lord, I may make a request, my lord. One of my cousin, my lord, is seriously suffering from cancer. I
Huh?
have to go to Nagaon and I have to come back to Guwahati today morning. So I couldn't prepare the case. So at least one day time may be given day after tomorrow, madam.
why?
Because I was unable to prepare the case.
Who
Because
is
I
there
have to
to prepare? What are these matters about?
matter regarding landlord tenant dispute.
Landlord tenant, why there are two matters?
Because they have filed one revision.
One issue has been decided so far default is concerned. Issue is decided against myself.
Okay. Whether the records have been called for?
Record not filed, but
Has the records been called for? If the records are not there, how can one
Yes.
decide the landlord tenant?
Yes.
We do one thing, we admit these matters. Records have not been called for, we call for the records and list it on a date on which Mr. Purkaster would be in a very good position to ask.
as a lot of person, I'm not going to, my lord, take any further time.
Both the petitions under under section 115 of the Code of Civil Procedure are filed challenging the order dated challenging the judgment and decree dated 18/12/2021, passed in title appeal number 31 of the 2017. Whereby the learned First Appellate Court decreed the suit for eviction of the defendant
So, roughly this
on
second
the
round
ground of
second round of refusal.
on the ground of
Bona fide requirement.
bona fide requirement. Who is the landlord?
I am for the landlord.
Name.
Puliram Nath.
The petitioner in CRP 100/2022 have assailed the impugned judgment and decree dated 18/12/2021 only on the ground that the question of defaulter, the issue of defaulter has gone against the landlord. On the other hand, the tenant, who is the petitioner in CRP 41/2022, assails the said judgment and decree, the impugned judgment and decree, on the ground that the learned First Appellate Court had wrongly decided the issue of bona fide requirement. Both the petitions accordingly stands admitted and listed for hearing on when?
I'm not going to
28th of May. No, records won't come.
record should come.
So early records won't.
20th of June, your lord.
28th.
20 on 26 2024. For hearing. The registry shall call for the records of the trial court as well as the First Appellate Court forthwith and ensure that the records are available on the next date so fixed.
Lord, there is an interim order in my case, my lord.
Hey,
CRP 41.
Mr. Putak,
Hello.
let me complete the order.
All right.
This court have also taken note of that this is the second round of litigation. And as such, an attempt shall be made to dispose of the said revision application, both the revision applications on the next date so fixed. So parties are given the liberty to mention the matter for upgrading. So the interim order so passed earlier stands extended till the next day.
Obliged. I'm sorry, my lord.
No? Without that, how can I decide?
Yes.
Although nowadays bona fide requirement is very, very tough nowadays for the tenant.
I have referred to some decision.
Decisions are all there, but
But
nowadays the Supreme Court has been very clear on
that's
that.
right. But there are
Very
some
difficult.
tests to be applied. Court cannot abruptly come to any conclusion.
Credit item 48.
Quickly. Always. Say,
Sorry, item 9.
Yes, what is this?
My lord, I'm the petitioner defendant, my lord.
Ah,
Suit, my lord. I'm the defendant number 1 to 3.
ah,
The plaintiff filed the suit.
Ah.
Respondent hearing, my lord. Filed
Hmm.
title suit for discussion of right title confirmation of possession.
Hmm.
Along with my lord, and my lord, for injunction, my lord. Miss Keith is also filed for injunction.
hmm.
My lord, and my lord, I am before your lordship. The
Who is the appellant plaintiff?
plaintiff, my lord,
He.
is the plaintiff.
And you are the
I am the defendant, my lord.
fantastic. Now the plaintiff, what has happened? What is the suit of the plaintiff? Yes, Mr. Kare.
Yes, my lord,
What
right
is your
title,
suit
right
for?
title interest and possession, my lord. Right title interest possession for declaration of right title and possession.
And you ask for what injunction?
My lord, restraining from dispossession by the defendants. My lord.
You are in possession?
Yes, my lord.
They are in possession.
They are claiming that they are in possession, but my lord,
And
I am claiming that I am in possession of the
And-
land, my
no problem. We ask, let our status quo be continued.
lord. What judgment is
My
here?
lord, total war court, my lord, finding is concurrent, my lord. Trial
Maybe that
trial
is what you say that you are in possession. Are you in possession or not?
yes, my lord. Trial court, my lord, finding is
Mr. Kate, are you in possession or not?
Yes.
Fantastic. Remain in possession. He says he is in possession. Let him remain in possession. That is also an injunction.
Yes.
You remain in possession. We say that both the parties have duly agreed that they are in possession. Each are in possession of their property. So the status quo be maintained till the disposal of the suit.
Fine.
Okay. This is an application under Section 227 of the Article 227 of the Constitution, challenging the order dated 5/8/2022, passed in Miss Appeal number 1/2021 by the Court of the Civil Judge Hailakandi in Miss Appeal number 1/2021, whereby the learned First Appellate Court affirmed the order of granting injunction by the learned trial court in Ms. case number 85/2019, arising out of title suit number 41/2019. From the materials on record, it reveals that the respondents herein, as plaintiffs, have instituted a suit seeking declaration of their right title interest as well as for confirmation of possession. Confirmation of possession, na?
Yes, sir.
as well as for confirmation of possession. In the said suit, which was registered and numbered as statute number 41 of 2019, the plaintiff also filed an application under Order 39, Rule 1 and 2, seeking a temporary injunction restraining the defendant from interfering with the peaceful possession of the suit land by the petitioner, and to protect the interest of the relief sought for by the petitioner. The learned trial court, after taking into account the materials on record, by the order dated 25/2/2020, disposed of the said interlocutory application, which was registered and numbered as Misde case number 85 of 2019, by directing the opposite party, by restraining the opposite parties from dispossessing the plaintiff oblique petitioner from the suit land, and it will be enforced till the disposal of the main suit. An appeal there was filed by the petitioners herein, challenging the said judgment order dated 25/2/2020, passed by the learned trial court. This appeal was registered and numbered as Miss Appeal number 1/2021. The learned first appellate court, after considering all the materials on record, came to a categorical finding, had dismissed the appeal by holding that the learned trial court was right in exercising the discretion in passing the injunction in favor of the plaintiffs. And being aggrieved, the instant proceedings have been initiated. This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the respondent. The counsel for the petitioner submit that the petitioners are in possession of the suit land, and as such, any order of restrainment to dispossess does not arise. He submitted that the injunction order so passed, thereby restraining the plaintiffs, defendants, not to interfere with the peaceful possession of the plaintiff, could have been passed had the plaintiffs been in possession of the suit land. On the other hand, Mr. M.J. Kadir, the learned counsel appearing on behalf of the respondents, who are the plaintiffs, submit that the plaintiffs are in possession of the suit land, and it is under such circumstances, and as the defendants oblique the petitioners herein were interfering with the peaceful possession of the plaintiff over the suit land, the suit was filed, as well as filed seeking declaration of right, title, and interest, as well as for confirmation of possession. And in addition to that, the injunction application was filed. This court, having taken note of that the orders passed by the learned first trial court as well as the first appellate court, finds no infirmity in the said order. This court is further of the opinion that whoever is in possession of the suit land shall continue to remain in possession of the suit land till the disposal of the suit. Accordingly, the parties herein are directed to maintain status quo in respect to the suit land till the disposal of the suit.
Okay. My lord, one of the prayer was for declaration of the sale deed is void, my lord. That was one of the
That
prayer.
is
Sale.
You're not on that.
Obliged.
On that.
Obliged.
Yes, what is this?
Yes, my lord, I am agreed by the
Eh, no,
order 24/4/2020 passed by the
wait.
I'm agreed by order passed by the court of the learned district civil judge number 3 Kamrup Metro, my lord, whereby my right of filing WS has been
Where? Which
the
order?
order is, my lord, 27, page number
20?
27. Next, sir,
Yes.
7. Page number
Learned counsel for the defendant has filed a petition seeking direction to the plaintiff to furnish copies of the petition on the ground that defendant has not discharged the complete. Strongly opposed to the demand. They do have it. In the petition, these documents regard review of the then
my lord, not kind, but on kindly I have
My lord,
page-
on the day one, injunction was granted, my lord. On the very next day, we have taken steps. We have submitted the affidavit on 14/2/2023, on which they had appeared. Their petition was silent as regards which are the documents we have not supplied, nor they have sought for any documents. On the next date, that is on 24/4, they have come up with an application that we have not furnished the complete set, but there is no
you
specific.
have got an injunction.
Yes.
Let the file.
Let them
even, my
file.
lord,
We
even
will
otherwise also, my lord,
Now have you got the copies of the documents or not?
that may be provided.
The copy.
And even
but I
otherwise,
can give it that. My lord.
Have it?
Yeah.
even otherwise,
You are the plaintiff counsel.
Yes.
You have an extra copy.
As of now, I can just give it within the day.
When are you filing? 30 days.
after receiving the copy of after that,
Today itself, I am
After no, you take it up in 11:50. By 11:30, I'm writing. After that, you make the copy and give it to him and take it up. You say that you have received the copy, file it within 30 days. Nothing. Suppose it's unnecessary. Lawyer. You give a copy.
My senior officer.
Who?
May be passed for the time.
Who is your senior?
Officer.
What happened?
He is on his leg in another court. Matter passport.
Huh?
He is on his leg in another court. Matter may be passed.
Pass over for the
Time.
Who pass over for the time? It's fine. Both is fine. Who is the other side?
Hard to pay.
Oh, I can't take it up. These people are related. This is the matter before any other. Any other.
May 30. सच्ची में पासपोर्ट मेरे पूरा टाइम नहीं है तो
Why?
पेन पुलिस सर्विस this velocity.
What is your case? FAO. of it all.
He's on exit port number 1.
I'll help you.
For a time being.
Tell me, what is the case? What are you challenging?
The order dated 12 to 2012 2023.
Very good.
Page number 175.
2012. All India Tea and Lady Company.
Married. Married. 175.
Notice was issued.
Yes, sir.
What happened on 11/3/2024?
Oh, sir.
What happened before the trial? What happened on 11?
Pending service.
You have appeared there?
Yes.
Then go there. Thing is there. What is there to decide here? Notice
Only
was
pending.
issued, then after that the matter is there. The court is not going to have. There will be two prongs of litigation out here.
Your Lordship, for the timing, he's on his way.
Ah, okay. You are appearing there before the court.
Yes.
Sir. Take it up after 5.
Yep, yep. Criminal appeal matter. Tape it.
Appearing on behalf of Trade by Corporation 2 weeks for taking stay. You are asking for stay?
Yes, yes. I find
It is a judgment for what? Because
yes, ma'am.
because granted.
I'll die husband. Why before it?
Okay. The instant appeal under section 28 of the Hindu Marriage Act 1955 challenges the impugned judgment and decree dated 7/11/2023 passed by the learned district judge in Murigaon entitled to second number 32 of the 2003, whereby the learned trial court had dissolved the marriage between the appellant as well as the appeal has been admitted, call for the report notice, making it returnable on 14th of June 2024. Steps be taken by way of registered as well as usual. The registry is further directed to call for LCR. This is an application under Order 41, Rule 5, read with Section 151 of the Code of Civil Procedure 1908, taking stay of the impugned judgment and decree dated 7/11/2023, passed by the learned district judge Murigaon, Assam, entitled to D number 32 of the 2019, whereby the decree of divorce was passed. Which provision is that? Filing an appeal is a stay?
Right, sir. The
Good
41.
Hindu marriage.
We file under Route 41. Right. Order 41.
Hindu marriage
Right.
act.
We file matter under Order 41. Right.
taking into account section 15 of the Hindu Marriage Act 1955 and the appeal having been admitted, this court is of the opinion that this is a fit case for stay of the judgment and decree dated 12th till the disposal of the according the judgment and decree dated 7/11/2023 passed by the learned district judge Morigao entitled to D number 12 shall remain state till the disposal. Yes, Mr. Chaudhary. What remains in the case? Why there should be two pronged matters, one out there and one here? The case where notice was issued,
Yes,
your only anxiety at that point of time
yes.
was there was a status quo order. There was only a notice was issued. Here you got a status quo. So under such circumstances, let the trial court decide that
Yes.
and let the status quo be remain till the disposal.
Absolutely.
And we direct the trial court to decide within 30 days.
Yes.
What is that?
Only
Nothing
thing
else.
is that, my lord, here no injunction petition has been moved here, and no prayer for status quo has been filed by the
There's
appellant
no
here.
injunction petition here.
No, my. Only to that effect.
Huh? No injunction.
Sure.
There's no IA. Tricky. IA he has filed. You have filed an IA.
We are filing an IWA for vacating of the stay.
There's no IA filed here.
No,
Then what type of order is it?
I
And help you.
Lord, prayer was made. There's a technical defect, my lord. Let
It's
it
not
come
a
up in-
technical defect. The power is not there. Even I can't pass an order to the effect. How
So,
can
my
a person pass an order in an app in a how?
My lord, to be honest,
We do one thing.
Yes.
We allow you to file an application before the trial court on
Yes.
an urgent basis, taking into account and if the learned trial court may take it up on an urgent basis and dispose it out.
and that status quo till that day it will be.
I'll give you time till
but
13,
the next date fixed on 27th of in the trial.
37. No.
27th of
I give them time till 13/5
Right.
to file an application. Until then, the status quo which has been passed will be continued. And then the trial court shall proceed.
So, my lord, trial court injunction petition otherwise there.
Understood. But you don't have
Yes.
here. How do I give you?
I'm following.
Because the next date is on 27.
My lord.
So that is the only way I can protect it.
Yes.
Otherwise,
Correct.
I would have, in fact, if this matter was moved before me, I would have not, in fact,
So, my lord, even
done anything.
I was never under the impression that there is no separate IF.
And only thing is, my lord, the point of jurisdiction, whether this court can pass any
Otherwise,
Why?
I would have loved to argue this matter before lordship.
Why?
page 96.
So, my lord, I think
Eh?
there are
96, my lord. That has been taken care of by the trial court. That's why the expertise index.
no. On the ground that page 176. On
Right.
the ground that in terms of their clause, my lord, court
Page
of Kolkata
96
was
was
given the
22.
exclusive jurisdiction.
Ah.
Section 16, the CPC is very clear, my lord. It's a suit relating to immovable property. How can by agreement I can agree to another jurisdiction? It's a tea garden, my lord. It is within the jurisdiction of the court. The court did not consider only.
Let us not enter into that. This is an appeal filed under order 43, heard Mr. K. Chaudhary, the learned senior counsel, assisted by Mr. T. Deori, the learned counsel for the appellant, and Mr. K. Sharma, the learned counsel, appearing on behalf of the respondent. This is an appeal under order 43, rule 1R, challenging the order dated 20/12/2023 in Ms. J case number 325/2023, arising out of title suit number 229/2023, only on the limited grievance that the learned trial court did not grant an ad interim ex parte injunction pending issuance of a notice. This court have duly taken note of that in the said proceeding, the learned trial court had fixed the matter on 11/3/2024, and in the instant appeal, was filed on 28/12/2023, and by an order dated 10/1/2024, this court had issued notice, admitted the appeal, and also passed an order that till the returnable date, both sides shall maintain status quo in respect to Kaliensara Tea Estate in the district of Kachar, Hilshire. The learned trial court, it has been also brought to the attention of this court that the respondent in the said suit, or the defendant in the said suit, have duly appeared. Have you filed your written statement? No. An objection.
The service is yet to be.
You have appeared or not?
I have
There.
the company has appeared, but the respondents are there. 8
We are not concerned. You are the injunction is raised against you,
Yes.
primarily.
Yes.
You have duly appeared. Have duly appeared. However, the written objection is yet to be filed. It has also been brought to the attention of this court that the next date is fixed on 27/5/2024. This court is of the opinion when the respondents are duly represented out there, have already appeared, have put in their appearance before as defendants in the suit, the continuation of a parallel injunction proceedings out here would not be in the interest of justice. Accordingly, this court directs the learned trial court, disposes of the instant appeal by directing the learned trial court to decide the said injunction application as expeditiously as possible. This court also takes note of that the instant appeal has been filed, but there is no application filed for granting an injunction, which is otherwise required for this appellate court to pass an order of injunction. So, taking into account that this court has remitted the matter back to the learned trial court to decide the injunction application expeditiously, this court fixed it proper that to continue the order
10/1/20.
of 10/1/2024 till 13/5/2024, on which date the learned the appellant herein would be at liberty to file an application seeking ad interim protection till the next date fixed, that is till 27/5/2024. As the parties are duly represented before this court, the parties are directed to appear before the learned first appellate court on 13/5/2024. And thereupon, the trial court shall take due notice of the observations made herein and dispose of the injunction application.
much.
So what to do with your IA? Did you file it?
No,
Very good.
Maybe.
What is it?
This is my lord, suit, appellant file a suit for specific performance in the color.
First appeal.
In the meantime, my lord, the respondent, he has, my lord, already after during the pendency of this my lord, proceeding, he has already, my lord, entered into agreement and sold some part of the land. So there is a compromise, scope of compromise is also going between the parties. My friend is also, my lord, last occasion submitted towards the honorable court. That the matrix repeated to the mediation.
Who will send it to the mediator? I can only send after admitting the appeal. Why should I send it? You file an application, go there.
Then let's say
Appeal. What is this? You have a judgment of mine?
my lord.
Why? An appeal lies under section 96. Oh,
My lord.
yeah.
I file
What is that matter about?
actually, the respondent owner of 154 bighas of land.
No. That order was something, some wrong order was there, but I couldn't do anything.
Earlier, I filed CRP,
Ah.
Then you
CRP for challenging what?
CRP for telling, there were two orders. First, the land court partly decreed the suit. Then I filed a review matter. So in my review, the respondent appeared and he took time for filing Vakalatnama. The next date was fixed for filing Vakalatnama and the objection. On that day, it matter was before the because of I could not reach in time. So my review was dismissed for default. So I challenged both the orders. So that's why I wrote.
Show me that order, the initial order.
Page
Oh, this one, page 85.
It starts from page 85.
Page 85.
Relevant page is 96. Para 21 is page 93.
In view of the above, where the plaintiff suit is decreed, partly, plaintiff is not entitled for a decree for declaration of right title and interest in effect that the plaintiff is entitled. The suit was partly decreed.
Only on the ground because in agreement it was changed as KP Patta number 1, but in fact it was FC Grant Patta number. So on that ground, that talent.
Okay, so appeal is admitted. Heard Mr. J.C. Gaur, the learned counsel, appearing on behalf of the appellant, and Mr. A. Ganguly appearing on behalf of the respondent. So the instant appeal is directed against the judgment and decree dated 22/3/2018, passed in title suit number 53/2016. So the appeal is admitted. Call for the records. Taking into account that the respondents are duly represented, there is no necessity of issuing any fresh notice. However, an extra copy of the memo of appeal be served upon. List after completion of, list after receipt of that. Yes, what happened the next date?
Next date, Lordship, it is 6,000. This is the order first. 22nd of May. For SR
It was listed on 23. The step was not taken.
You have not taken steps also.
No, thereafter, I was not the counsel in court before.
I can't help it.
Then steps
No,
were taken.
Mr. Roy, I can't help you whether you are the counsel there or not. Your client should have been better advised to keep Mr. S.P. Roy as the counsel there. They have not.
We have taken a step, Lordship, later on.
Yeah.
With the
No, but
permission from the-
why should this court at all consider this thing? They can only step on 22/5, and it is against whom?
GNQ.
All are representing there.
Hello?
22/5, you are going to appear there.
Yes, I am going to appear.
Now, what injunction you want?
Lordship, the Lordship knows that
They have already constructed the wall.
they have erected a gate, Lordship, in front of the gate of the hospital, Lordship.
Not in front of the hospital, on the side of the hospital. And from that gate, you can't see even your hospital.
No,
In
now
fact,
I have, Lordship,
everything construction is complete in March.
Lordship, I am
March
submitting,
itself, the construction is complete.
March
March
completed.
itself.
So nothing remains.
Nothing remains.
Better, I think you depend your
Lordship, I have
application.
submitted 10 numbers of photographs taken by drone survey, which clearly shows the position, Lord.
Where is your hospital?
Hospital, only I have written, why is it your?
And whose land is this in between? In between whose land is this?
This is the government tax.
This entire land is somebody else.
No, government land. I
Oh.
am claiming inventory right under section 25 and 27.
On this land.
Yes, only for passage of 30 feet.
And why? Where is no, Mr. Roy? where is the road to come from that hospital and go there?
Lordship, at the bottom, that is the public road, Lordship, which starts from.
Not this one. From your place.
Yes, yes.
In your area, within your boundary, where is the road?
There is no
Road
road.
is-
Government-
Gate is visible, Lordship.
Gate
have
is
written
visible, but
hospital.
where is the road?
Road is this,
Where is the road out there?
Lordship, as per the.
Yes, have you seen this?
Smart
Well,
city.
I have seen it, the photograph here. There is no road, my lord. Only
No.
thing is there is a main road, main
they are-
alternative
they are-
entrance gate of the hospital.
Lordship, even if it's a government land, like if I have used for 30 years, Lordship. I have been
Whatever, maybe let the trial court decide.
la-
whatever
la-
may be.
using.
Or road, there's nothing, there's not a single road out there to the gate. This is the
Lordship, my
third
case
gate.
is entirely different, Lordship.
How do you go by that road? You do one
Yeah,
thing,
no, no,
Mr.
you see,
Roy.
Lordship,
No, Mr. Roy, you do one thing. You show to Mr. Bora by driving your car in that place to that gate, he would
I can
obviously
do, I
allow.
can do. Lordship, may I come to page 3 of the photograph. Internal, all roads are
It's
shown.
Kindly come to page 4. Page 4. Kindly see where the gate is. And
Gate
where is the road? There is any road,
There
there is
is in-
nothing
all
out there.
Inside the internal, all roads are shown, Lordship, connecting the gate.
Hello? No case. Dismissed.
Lordship, I may be hard.
I'm hearing. What else do you
No,
have?
no, Lordship, where there is a road, when I am claiming that I have the easement right, Lordship, under section 25 and 27. of the
Understood.
Limitation Act.
Mr. Roy, it is a case where notice was issued only. There was not an ad interim injunction granted. Against that, on the matter now fixed on 22/5/2024, they are going to appear. Let the trial court decide. Why should this court entertain this and at this time when you have not taken the steps thereupon?
Subsequently, the steps were taken. which
And
was
in the
allowed.
meantime, they have already constructed. You want a demolition, a mandatory injunction on the basis of a notice? Is it conceivable
Ad interim
that you want a
injunction,
demolition?
Lordship, under section 34 of the SR Act, ad interim injunction can be granted for removal of the nuisance lot. This is
Under section
34
of
of the SR Act.
34 is
Sorry, 37.
39.
37, 39. I may not remember correctly. There is a provision. And apart from that, Lordship, injunction.
Mr. Roy, don't go into those technicality, those aspects. If you argue, I'll have to answer. If you answer, then it goes against it.
No,
The
no,
entire injunction.
Only
will-
one submission, Lord.
Yes.
My injunction was not granted to the appellant, Lordship, only on the ground that their hospital is having alternative road from the western side, that is Kesi Chaudhary Chhatribari Road, Lord. That cannot be a ground, Lordship, for not issuing the injunction, Lordship. As per the decision laid down by our this honorable court, that once a prescriptive right is acquired, Lordship, that cannot be denied on the plea that there is alternative. That is your judgment of 2003 3 JLR, page 160, para 5.
Yes, where?
Para 5.
Hmm.
Second page. The word shall be absolute and indefeasible occurring in section 1 and make it clear that any right title interest created as an easement shall be absolute and indefeasible. Therefore, if in a given case it is proved that any right title interest has been accrued in favor of a party, the same cannot be
Mr.
adversely
Roy.
affected.
Mr. Roy. Suit was dismissed. It was the first appeal. Second appeal.
But this is
We are at the stage where notice. We'll see. You may win the case next. And after winning the case, everything will happen.
the Lordship, my humble prayer is let the
Withdraw.
latter trial be directed to dispose of the injunction application at least within 10 days.
How?
They will-
How?
they will
You
find-
have not taken steps. How?
Really, I have taken, I have
You took only steps when the court said that nothing doing. You did not take any steps till then. You took steps on 33/2024. You are supposed to take steps within within the 24 hours. Why haven't you taken steps if you wanted an injunction?
The earlier learned council probably
So
forget to
you
take.
can't blame the council again. Well, Mr. Roy, I don't like blaming of the council. You
No,
know,
no, I was not
better
the council.
I say that you will ask for I'll ask both the parties to appear before the trial court on a particular date on 17th.
It is fixed, my lord. It is fixed, my lord.
On 22.
22 5.
They will appear, and on that day you will file your written objection.
Till then, no further constructions would be constructed.
What?
Till then,
There's nothing to construct. And I'm not at all
and
satisfied.
Lordship, today I have come to know that as per the Smart City approved plan,
Ah.
this disputed passage, Lordship, has been shown as a public road. It's just today I come to, I'll be able to produce
Yeah.
before the learned trial.
I think when you have come to know now, you need to make necessary amendment to your plea. Anyways, you say, this is an appeal. This appeal under Order 43, Rule 1R of the Code of Civil Procedure 1908 is directed against the order dated 28/2/2024 passed by the Learned Trial Court, whereby the Learned Trial Court had refused to grant an ad interim ex parte injunction against the respondents in the said appeal, in the said suit, against the defendants in the said suit, and issued notice thereby fixing 23/2024 for SR and objection. This court further finds it very pertinent to take note of, that the instant appeal was filed on 19/4/2024. In the meantime, not only the date of 23/2024 have passed by, but also the appellant herein did not even take steps immediately after the passing of the order dated 22/2024 by the Learned Trial Court. Today, it has been brought to the attention of this court that on account of no steps being taken, the Learned Trial Court had, by order dated 23/2024, fixed the matter on 22/5/2024 for SR and objection. Mr. S.P. Roy, the Learned Counsel, appearing on behalf of the appellants, submit that steps were only taken on 30/3/2024. Under such circumstances, this court is not inclined to entertain the instant appeal at this stage. This court, however, takes note of that the respondents herein, who are the defendants in the suit, are in know of the facts of the instant case. The facts of the title suit pending before the Learned Trial Court, as well as the injunction application. The respondents shall file their objection, written objection.
Private respondent, respondent of court.
No, you.
From the GM.
The respondent,
GMC contract.
Huh?
International
The respondents,
Code is
GMC, are directed to file their objections before the Learned Trial Court on 22/5/2024 in respect to the injunction application. The Learned Trial Court shall pursuant to such objections being filed, decide the said injunction application at the earliest and preferably within 30 days thereafter. I think both appeals. Yes, you take this photograph. It will be helpful for filing your objection.
Okay.
In fact, Mr. Bora, this appeal, the suit itself is not maintainable. on the ground that it is only a suit for permanent injunction. And why injunction only asked for? Otherwise, you have the mandatory notice to be issued. Because there is no exemption under 82. So what he has done, he has only filed a suit for injunction. But how can he ask for easementary right without seeking a declaration?
Nothing.
Yes. Yes, madam.
We have filed this appeal, my lord, against order dated, my lord, judgment and order dated 18/1/24, my passed by learned tribunal MSCT Supi, my lord, pertaining to two grounds mainly, my lord. One is, my lord, the accident occurred due to,
Who are you?
my lord, we are in insurance company.
Insurance. Yes, what is it?
My lord,
What are your two grounds?
my lord, the said accident occurred due to head-on collision between two vehicles, my lord. But learned tribunal totally ignored the contributory negligence, first, my lord. And second, my lord, the state vehicles have no valid license.
Who?
My lord, the truck, my lord.
Which truck? Truck number?
Truck number, my lord,
Hello, madam, we issue notice on this. And in this, we'll admit the appeal, but no stay on this. No, I'm not staying it.
appearing, my lord, after appearing.
After appeal. Take on Lahok, appeal to Lahok. This appeal is an appeal under Section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 18/1/2024 passed by the learned member Motor Accidents Claims Tribunal Dhubri in MSC case number 20 number 337/2015. The instant appeal primarily is directed against the impugned judgment and award on the grounds that the learned tribunal failed to take note of the aspect of contributory negligence and on the ground that the appellant on the ground that the vehicle in question did not have a valid insurance.
At the time of
The appeal is admitted, call for the records, list the matter again on 24/6/2024. This is an heard Mr. and so the learned counsel appearing on behalf of the applicant. This is an application seeking stay of the judgment and award dated 18/1/2024, passed in MSC case number 337/2015. Issue notice making it returnable on 24/6/2024. This court would consider the stay of the impugned award upon hearing the claimant.
Okay.
List according. This is an application under Article 227 of the Constitution challenging the order dated 4/4/2023, whereby the learned court of the civil court number 3, Kamrup Metro at Guwahati, by the impugned order, rejected the application filed by the petitioner, who are the defendants in the suit, to file the written statement, and further directed that the suit shall proceed without the written statement filed by the defendant. Upon hearing the learned counsel for the party, it appears that the controversy is as regards the non-receipt of the documents which were filed along with the claim. Mr. G. When appearing on behalf of the respondent, duly submits that the documents were duly furnished and the defendant had filed an application initially and did not mention anything as regards non-receipt of the document. However, subsequently on 24/4/2023, that said application was filed that they have not received the document. He therefore submitted that this is a ploy employed by the defendants to delay the disposal of the suit. This court, upon taking into account that the controversy surrounds around as to whether the documents were furnished to the defendants or the defendant along with the plaintiff, is of the opinion that the ends of justice will be met, that a copy of the documents filed along with the plaintiff be served upon the counsel appearing on behalf of the defendant, so that the written statement could be filed. So accordingly, during the course of the hearing, the learned counsel appearing on behalf of the respondent duly had furnished a copy of the copies of the documents which have been filed along with the plaintiff to the counsel appearing on behalf of the petitioner, who is also the counsel appearing on behalf of the defendant. This court interferes with the order dated 24/4/2023 and directs the and grants the liberty to the defendants to file their written statement by by 7th of June 2024. Full stop. It is made clear that if the defendants fail to file their written statement by 7th of June 2024, the order dated 24/4/2023 shall stand revived, and the trial court shall thereupon proceed with the suit in accordance with law. With the above, the instant petition stands disposed. This court further vacates the order dated 21/7/2023 and as the parties are duly represented, they are directed to appear before the learned trial court on 7/6/2024. Yes, Mr. A.R. Agarwal. We don't see you nowadays.
This at least prepared by the claimant for enhancement of complexity.
What is the enhancement?
Yes, Lord.
Why?
This is the imputation case, Lord. Permanent eligibility is 85%, but the Lana court below is taken 65%. And this is imputation about
Why the enhancement you are asking for?
income on the grounds of income and eligibility grounds, Lord.
Income, what is the wrong? You
Income
can file
was
an appeal just for the sake of
15,000, Lord. And
how much?
Lana court below is taken 8,000.
15,000.
Yes, Lord.
Your income was how much?
50,000. Carpenter, Lord.
Carpenter.
Eligibility is
What
taken less.
document did you submit for
No,
50,000?
Lord, just in the oral evidence, Lord.
So?
So carpenter is skilled labor.
So?
So the income, this prevailing income is 10,500. And again, imputation taken
Huh?
lesser load.
Carpenter.
Yes, sir.
What document? What evidence did you give that he had 15,000?
Yes, Lord, this is oral by oral evidence, Lord.
What is the oral evidence?
That was not challenged, Lord.
No, not challenge is a different thing. What oral evidence did you give? 15,000. And how did the trial court decide that?
Unskilled labor that is decided, Lord. But the carpenter is skilled labor. Carpenter is skilled labor.
Where is it? When did the accident happen?
6/10/2000.
Hmm?
6/10/19.
6/10/2019.
I can just say it will be taken lesser than that evidence. Subsequent may continue.
You have only mentioned that you have got 15,000
Yes, sir.
in your evidence.
I am a carpenter. That was not challenged even by the OP.
Oh, forget about the OPs, but you have to show something that you have getting 15,000.
My profession is in I stated. Oral
What have you
evidence,
said?
oral evidence I said
Where is your oral?
that is in the
Okay, show it to me. I don't admit this type of appeal. It's a matter of truth. On which state Mr. Yara substitute the evidence on the basis of which the appellant claims to be entitled to higher.
again this imputation load that disability load. Disability is also taken lesser.
So what? You're given 65.
Yes, sir.
It is above the knee.
Above this.
So?
Notice my country.
What should I do?
Note.
Notice what? First
Notice.
you have to show me. This notice is unnecessary. Why should I just enhancement of?
Yes, sir.
You have to show something. Why? It's a matter of the on which state Mr. A.R. use the oral evidence of the shall produce the evidence of the party, including the evidence on affidavit of the PW2 and his prosecution.
Yeah, Lordship, my case is dismissed, Lordship, because on non-implementation of party load. Non-implementation of party load. Because I am the father and mother of the deceased, Lordship.
You are the?
Father and mother of the deceased. And this is one lady, and she was earlier married, but she was deserted, Lordship. Long back. So I am comfortable में kindly.
You say that PW2 one had stated that the victim was a unmarried daughter. But during the cross, you say that she is married, she has a son. And you have not made them a party. Why?
The thing is, this she was deserted by the husband.
So what?
Long back.
He is entitled to. What about the son?
Who don't know where they are.
What are the son?
They are not staying with us.
So what? What are the names of the son? We can make them party.
But since that it is dismissal, so
there might be a case that the son and mother or the wife have already taken.
No, that has not come.
That the husband is already there.
Yes,
Ananda Roy.
Husband has deserted me, though.
Deserted whom?
The deceased Lord.
Husband had deserted the deceased. And then what about the son? Son also had deserted.
Husband, Lord.
Huh?
That husband is, the son is also staying with the husband, Lordship.
So they are not entitled to.
No, they are entitled, Lordship, but
Then
they have not been made party. And
Why?
on that
why?
ground,
And why did you make a false statement that she is unmarried?
no, Lordship. she
You
was
made a false
deserted.
statement.
Actually, village lady, she don't know actually everything. So if you don't know even where is the
It will
husband.
Agor order to দিব. This is the matter after 2 weeks on which date Mr. A.R. Agarwal shall produce the evidence of PW1. Yes, the cloudy matter.
And the railway can clear the cloud.
Hello, let's see. What are you asking for? You are seeking a review.
Right. There is a-
Why?
Here is a revision petition filed by the State of Assam before the Honorable Court against the attachment order in the execution court. I am a degree holder. I instituted the execution proceeding. In that execution proceeding, my lord, money was not been paid. So attachment order was passed. Against that attachment.
It's a LA reference.
Right.
LA reference, the award was passed in your favor. And against that, you have gone for an execution.
There is a decree, my lord. There is a decree before the court. That decree, I filed an execution case. In the execution proceeding, my lord, there is an order passed by the executing court regarding assessment of some account of the government. And against that, only that assessment order, government state of has a different court. So, that I page 11, my lord, your lordship kindly.
Page 45? No.
No, your lordship kindly step goes to my lord division. Division filed by the government. Not review, my lord. I want to go that they are.
Where's the order which you are seeking review?
But that is my lord order. Page 57.
Against the order dated 7/9/2019 of the learned district judge in so and another order dated 7/9 in so and so are execution of awarded amount as per the judgment and award dated so passed by the Imani so. As the awarded amount has not been paid by the land was instituted so by 2 orders tribune. In the present position, the part of has attached the revenue deposit account of the Yes, why it has been said to be irresponsible? That is the course which is being done.
My lord, because we have not received any
Isn't it,
notice.
Mr. Muzunda?
Then no, my lord,
How
already.
do you take care of an amount to be paid to from the amount you want to stake against the government? First, DC's office. The DC's revenue account. That's the normal course of events. How is that paragraph 6 is being mentioned?
Which page?
Page 60.
It's
If this proposition remains out there as a law, it would be next to impossible in getting the award or a degree satisfied.
My lord, that day they cannot, the honorable court cannot adjudicate that matter, my lord, because that order is known as my lord. Already set aside by the executing court, my lord. That
So-
order which challenged before the honorable court by the government. On that particular date, that was decided on your lordship kindly see on 1/12/2023.
1/12/2020, this matter was heard, my lord. And on that day, my lord, impugn order was already, my lord, set aside by the trial court, by my executing court, my lord. So, lordship, kindly see, my lord, page
53.
50. On the application filed by the state, my lord,
On 36/2021.
my lord.
Then
Page 50. So, my lord, by this order passed by this honorable court, the execution proceeding has been, my lord, closed.
What?
Your lordship, kindly see the order. Yeah, the Anand district judge directed to close the RLA execution case number 20.
where?
Para 7. Para 7, page 60, madam.
As the amount has already been paid to the landowners, and it is the landowners who are evading further appearance in the court and not being paid the justice, and the two orders dated 20 are set aside.
The Anand
The
district
learned
judge
judge
Dhubri
is
tried-
directed to close the LA case by following the due procedure of law. In doing so, notice will also be issued to the applicant and so to explain their conduct as to why they have abused the justice. Why is he saying about the just abuse?
Well, there is a reason.
I'm sorry, my lord, because I have
Yeah.
not getting my.
My learned friend was not there. I was there. I can explain.
Yes, please.
Well, what has happened, man? Right from the beginning, in pre-file, there was an award, and it was acquired for the railway. Railway got the land. Awarded amount was also paid to the landowner. Thereafter, there was a reference for enhancement. Before the reference court, the railway was not made a part. So possibly they are not aware of the enhancement of the award. Then they gone to the executing court because they have not got the money. Before the executing court, possibly on behalf of the state collector, time was paid for ensuring whether payment has been made or not. Thereafter, on one particular date, the attachment order was passed, open account. Then we came before counter court saying that we have acquired the land for the railways. Railways has to pay. So railway also not appearing with this. I can make railway as party. Owners were made party. They did not appear before the company. Now, after 2 years, when the matter came up, then from our side, we ensured that the railway appeal is tagged along with this. When the railway appeal was tagged, railway council appeared. They said that we have made the full payment of the amount
Of the decreed amount.
Yes.
Then
I insisted that no, mere statement, oral statement will not do. Kindly produce document that you have made the full payment. Then they filed an affidavit saying that initially 50% was paid, and subsequently another remaining 50% was also paid. So nothing is remaining pending, and therefore we are withdrawing the appeal. Now in the appeal, one order was passed. Kindly have a look at it. They filed the appeal with an application for prolongation of delay, and that matter was pending for 1 year. In the meantime, we are facing attachment, etc.
Then you have disbursed.
Hello?
They say in this order that the railway had duly paid the amount to you.
They have stated the amount was paid and the owners have received the amount.
No. Have paid the amount to the district collector.
From
district collector has disbursed.
Yes.
That's a different thing.
My lord.
Because
No,
then the
really?
question is different. No. You see, the question is the requiring authority may very well pay to the acquiring authority.
Absolutely. It is
But
the,
it is also the duty
of
of the
the,
acquiring authority, taking into account that they charge 8%. You don't do it for free.
yes,
You charge 8% for the purpose of doing all these things.
yes,
So when it is your responsibility to pay it to the landowner,
yes,
or
yes.
you have to tender it, or you have to deposit in the court under Section 30. Did you do that?
my lord. My instruction, my landlord appeared and said that entire amount is free. Correct?
Anyway, as per your instruction, the amount has been paid.
Paid.
Now, they say that the entire amount they have not got it. That matter can very well be taken up in the execution.
Absolutely, I've got no difference.
Then where is the question of
When
closing?
this revision was disposed of, this Honorable Court, on the basis of the submissions made on behalf of the railways, was satisfied that the entire amount has been paid.
Understood, but
Now
the
if they say,
other side was never taken into notice because it was still at the stage of condonation
But-
application.
but one thing, my lord, when notice went from this Honorable Court in the revision, and Lord, may kindly have a look at page 10 of this revision petition. They were aware at one stage that this interim order, which was passed by the Honorable Court in the revision, staying the order impugned. Then this was intimated to the executive court. They were contesting there. Had they appeared before the on court, this situation would not have arisen.
But whether the notice has been given,
No. Yes, to one of them it was served, my lord. In IA, notice was served to respond number 3.
but whatever means out here,
Right.
it's a simple aspect.
My lord, executing.
It is a very simple aspect. I
Well-
don't understand why. Because you see, when a order first, yes, one has to understand that if you look into Section 20 of the Act of 1894, it categorically says that who are required to be made parties. If it is a case of enhancement,
Right.
it is only the acquiring authority has to be made a party.
Yes. No, my lord. That's why the Supreme Court has made it clear.
Then the matter went in Supreme Court in 1993. The Supreme Court says that the requiring authority also have a right.
Absolutely.
So they should also be made a party. Now, it is not being done by whom? By the
By-
court.
In fact, my lord, they
No,
also.
it is not them.
Court
They
should-
only seek a
The
reference.
Lordship is correct, my lord. Supreme Court has said that court should issue notice.
Absolutely. In fact, if you see Section 18,
Right.
they are only to say that look here, this is the 100 rupees I have to get, but they are giving me 50 rupees, and
Correct.
this is why I seek a reference on these grounds.
I understood, my lord. Let us not extend it further. I have no difficulty if the execution case is opened and they are allowed to place their case that how much more the money spent.
Without dehorse these
My lord,
observations, because
Right.
these observations, you see, one has to understand how
Well, I
on
only,
earth can you
my lord, I only explained as to in what circumstances the court is passed. Court was satisfied that the entire amount has been paid because they were not here. Had they been,
court couldn't have arrived at a satisfaction to that effect unless they were duly represented.
Lordship and direct that the execution case will proceed, they will place whatever amount they due is there.
We
But so
review
far
this
as-
order.
My lord, so, yes. My lord, so
We
far as
review this
railways are
order. These
concerned-
observations were not at all necessary.
Right.
However, the executing court shall hear, they say that they have paid the entire amount. The district collector says that the amount has already been
Let it be
disbursed. However, if the appellants are, the petitioners are not here, they can very well agitate before the executing
Right.
court, and the executing court shall look into that.
Yes, yes.
You want that
That-
one?
My lord.
That will
Okay. Some cloud is removed.
I only explained the circumstances under which this it was closed.
This is an application under section 114. 114?
Yes.
114, read with order 47, rule 1 of the Code of Civil Procedure 1908, seeking review of the order dated 1/12/2023 in CRP IO number 40/2020. For deciding as to whether the order dated (1/12/2023) comes within the ambit of the review jurisdiction to be exercised by this court. This court finds it relevant to refer to certain facts which led to the passing of the order dated 1/12/2023 by this court. The petitioners herein filed application under Section 18 of the Land Acquisition Act 1894, being dissatisfied with the compensation so awarded in LA case number 2/2004-05. That's the only case. How many cases did you file?
Only one case,
LA case is 2/2004-5.
but there's a two common judgment passed.
Maybe. Are these the petitioner? We have, because annexure 1 is that applicant.
Right.
There's no other applicant.
Right.
Upon the said application being filed, the collector Dhubri, in exercise of his powers under Section 19 of the Act of 1894, made the reference to the court of the district judge, Dhubri. The learned district judge Dhubri, by an award dated 18/1/2012, enhanced the compensation thereby fixing the market value of the acquired land at rupees 2,50,000. And thereby enhance the compensation. As the said awarded amount was not paid, the petitioners herein took the assistance of the court, sought the assistance of the court by filing an application seeking execution of the award dated 18/1/2012 in LA case number 16/2009. The said application was registered and numbered as Miss LA X case number 2/2015. In the said application, the respondents, herein which the state of Assam, as well as the collector Dhubri, duly participated. On 7/9/2019, the learned court of the district judge Dhubri attached the revenue account number 8443 C/D and 101/101R/D lying in the Dhubri Treasury Office till payment of the award. This order was put to challenge by the district collector Dhubri in CRP IO 40/2020. And this court, by an order dated 11/3/2020, state the operation of the impugn order dated 7/2019 passed by the learned executing court, that is the learned court district judge Dhubri, in Miss LA execution case number 2/15, as well as also in Miss LA execution case number 3/2015, which was in respect to another proceeding initiated seeking the assistance of the court. The said requisition, the said proceeding, that is CRPIO 40/2020, remained pending before this court. However, it is seen that the order which was stayed by this court was vacated. The order dated 7/9/2019, which was stayed by this court, was vacated by an order dated 30/6/2021 by the learned executing court, that is the court of the learned district judge Dhubri. It was vacated on the ground
on the application filed by the page 49 is the application filed by the collector. Page 49.
that an application was filed by the state of Assam stating inter alia that it was decided to make payment for the remaining part of the decretal amount and the payment in the meantime has been made ready in due process. On 1/12/2023, when this court had taken up the CRP IO 40/2020, the impugn order dated 7/9/2019 was therefore not in existence. Be that as it may, this court ought to have been informed by the counsel representing the state of Assam about the order dated 30/6/2021, as the order dated 7/9/2019 was not in existence. More so, when the order dated 30/6/2021 was passed at the behest of an application being filed by the state of Assam. Be that as it may, this court while deciding the said application, passing the order dated 1/12/2023, made certain remarks as regards the petitioners in abusing the process of the court, abusing the process of law, as well as closing of the execution proceedings. This court further finds it very pertinent at this stage to observe that these observations came into light, were made by this court primarily on made by this court on the ground that on that very date, the appeal filed by the NF Railway, wherein a condonation application for condoning the delay of 1,849 days was also taken up for consideration by this court. In the said condonation application being IA Civil 3617/2019, this court took into account an affidavit filed on 24/11/2023 by the requiring authority, that is the NF Railway, stating inter alia that the amount pursuant to the award passed on 18/1/2012 in LA case number 16/2009 LA appeal case number 16 have been duly deposited and deposited to the district collector Dhubri, and the district collector Dhubri in turn had disbursed the amount to the lawful claimants. It is under such circumstances these observations were being made, more particularly by this court in paragraph number 6 and 7 of the order dated 1/12/2023 sought to be reviewed. Mr. T.K. Mohanta, the learned senior counsel appearing on behalf of the petitioner, submit that the order which was passed by this court on 1/12/2023 was passed without taking into account the stand of the petitioners, and the observations so made were not at all required, taking into account that the order which was challenged in the said proceedings, that is on 7/9/2019, was no longer in existence in view of the order dated 30/6/2021 passed by the learned executing court by vacating the order dated 7/9/2019. He further submit that though the requiring authority may have paid the amount to the acquiring authority, but the fact remains as to whether the acquiring authority had duly deposited the said amount before the court or had tendered it before the claimants is a question which can only be decided by the executing court and not by this court. He therefore submitted that the closing of the execution case as directed by this court have therefore taken away the rights of the petitioners, which were there to be adjudicated, agitated, and decided by the executing court. Under such circumstances, it is therefore the submission of the learned senior counsel that an error apparent on the face of the record has crept in the order dated 1/12/2023. On the other hand, Mr. D. Mojumdar, the learned senior counsel representing the state of Assam as well as the collector Dhubri, submits that the amount have been deposited by the requiring authority, that is the NF Railway, and the same have been duly disbursed to the petitioner.
And we have a document.
And in that regard, wanted to place certain documents before this court.
Through RTGS it was paid.
He further submitted that these amounts were duly paid through RTGS. He, however, duly admits that as on 7/1/12/2023, the order dated 7/9/2019 was no longer in existence. Yes, you are there also. Indeed, Ms. Again, the learned counsel appearing on behalf of the petitioner, requiring authority, that is the NF Railway, submits that the decretal amount as per the judgment and award dated 18/1/2012 in LA case number appeal case number 16/2009 have been duly deposited before the district collector Dhubri, and the said amount have also been duly disbursed by the district collector Dhubri to her information. This court, upon giving an anxious consideration to the respective submissions as mentioned herein above, and also taking into account the facts, is of the opinion that the observations so made in paragraph number 6 and 7 was not at all necessary by this court, on the ground that as on 1/12/2023, the order which was impugned, that is dated 7/9/2019, was no longer in existence. And had that aspect of the matter been brought to the attention of this court would not have passed the order dated 1/12/2023. In addition to that, this court also finds it relevant to take note of that when the executing court was seized with the matter and is the authority as per law to decide as to whether the said amount have been paid or not, this court, in exercise of the powers under Article 2 to 7 of the Constitution, ought not to have interfered with the said power, since there was some sense the order of the executing court was such which would shock the judicial conscience of this court. Under such circumstances, this court is of the opinion that there was an error apparent on the face of the record in passing the order dated 1/12/2023, insofar as the observations so made in paragraph number 6 and 7 of the order dated 1/12/2023. Accordingly, this court reviews the said order dated 1/12/2023 and this court thereupon, this court further thereupon heard the learned counsels appearing on behalf of the parties on the legality and validity of the order dated 7/9/2019, which was challenged in CRP IO number 40/2000. Accordingly, reviews the order. Review then and reviews the order dated 1/12/2023 and therefore takes up the CRPIO 40/2020 for hearing. এইটো হৈ গ'ল, CRPI খন দিয়ক। In view of the order being passed in RP review petition number 56/2024, the instant application under Article 227 of the Constitution challenging the order dated 7/9/2019 in LA case number 2/2015 and LA case number 3/2015 is taken up for hearing. This court have duly heard the learned counsel, senior counsel appearing on behalf of the respondents, duly heard the learned counsel, Mr. D. Mojumdar, appearing on behalf of the petitioner. Mr. T.J. Mohanto, the learned counsel, appears on behalf of the respondent numbers 1 to 6.
No, my 1 and 2 already died. I am 3, 4, 5, 6.
Appearing on behalf of the respondent number 3, 4, 5, and 6. And Ms. A. Gayan appears on behalf of the respondent number 7. It has been submitted by the learned counsel appearing on behalf of the petitioner that the order dated 7/9/2019, which was put to challenge in the instant proceeding, is no longer in existence in view of the order dated 36/2021 passed by the learned executing court, thereby vacating the order dated 7/9/2019. The learned senior counsel therefore submits that the instant proceedings have become infructuous. Accordingly, the instant petition stands closed as infructuous.
Now, but cloud has been removed.
Itu revive কৰিলো, itu dispose, CRPIO dispose.
Okay. Difficulty arises because of not following that procedure of repeating the requiring.
These continue out there.
Legislation.
Today I'm delivering a judgment at 2 o'clock on the question of how a requisition is made. Important judgment.
Yes.
You can't keep a matter for requisition for each.
Thank you.
54. Oh yes, where are they? Mr. B.D. Deka, where are these people? Yes, what is this?
Right, please, Your Lordship. My lord, we are aggrieved by an order of remand passed by the Appellate Court, Lord.
Remand?
Yes.
Why you are challenging under 115?
Lord, it's a landlord tenant. So 43(1) says, my lord, where an appeal would lie against the appellate. Your Lordship takes up 43(1) as a conviction. An order under 23 or 23A of Order 41 remanding a case where an appeal could lie from the decree of the appellate.
So in view of section 8, then tell me.
But suit was filed on 2 grounds, my lord. Bona fide requirement that default down.
So here the issue is very small as to whether it should have been remanded or not, or court should have exercised the power under Order 41 Rule 20. That's it.
My lord, and that apart, my lord, the decree was passed on the ground of default and bona fide requirement. Now, the appellate court framed the point for determination.
Where is that order?
Page 131 it starts, my lord. 130 it starts. 130. Now, my lord, if the lordship comes to the issues framed, my lord, issues are reflected at page 133. Page one.
Where's the order? Let's see why the court could not decide.
Page 139.
Removal of the record of the learned trial court reveals that after chief of continental was the case of Hen court. And what the decree was passed on the what?
Both under defaulted bona fide required. But
Then why did he remand?
and
What about the bona fide requirement?
no discussion, nothing.
Eh?
Page
Why was it remanded?
Page 140, my lord, the findings in issue number 3 also have been satisfied by discussing only default.
Then how could it be?
Exactly.
No, my lord,
Nothing to us.
so with regard to one thing, lordship, also may kindly come to page number 47. Of the
No. There was a decree for bona fide. The first appellate court could have passed it on. And if it has set aside without deciding, it has failed to exercise the powers of the order 41 to 31. That is the mandatory duty. Why he didn't do it? Secondly, what stopped him from getting the NJ case? Did you file an application on the order 41 rule 27?
No, we did not.
Then why will the trial court, first appellate court, go search that how many NJ cases are there or not?
My lord, with regard to that,
It is you and the appellant. So under such circumstances, it was your responsibility of the first for the appellant to file an application under order 41 rule 27 that these are the other evidence which ought to have been taken into account. Why nothing has been done?
my lord, that part, lordship, I accept, lordship. But the one thing I would like to point out, lordship, that para number 26, I have nothing to say with regard to that, lordship.
Para number?
Para number 26, that has been reflected what my current patient argued, lordship.
Then nothing
But
remains.
no, lordship, with regard to due date, the reason why the matter was remanded back, lordship, was for determination of a due date, lordship. Now, in that respect, lordship, I would just like to, lordship, may kindly see page number 47.
No, understood. Due date. Let us understand. Okay, let it be. Why there was no evidence? Why do you need the NJ cases for that?
No, lordship, NJ case is a separate aspect and due date is a separate aspect, lordship.
Therefore, that was not the ground.
Yes, that is the ground. I am coming to that.
No. That is not the ground for remanding.
That is the ground, lordship.
Then why was he could not be decided?
Lordship, I'll just come to that, lordship.
Yeah. Why?
Lordship, may kindly 113, lordship, the finding of the court
Eight.
below. 113, lordship.
113?
Yes, lord.
Why should we go to 113? There's a
That-
trial court judge. I'm not on that. I'm saying on why not in the appellate court? Why the due date could not be decided by the appellate court?
Lordship, because the evidence was not sustained. That is what I'm trying to refer, lordship. The appellate court judgment. Lord.
Show me that. The appellate court judgment starts from 130.
Yes, lord.
Why you are going to 113?
134, lordship.
Yes.
Heard the counsel for both the sides. The appellant defendant stated that the trial court failed to appreciate the evidence in the proper perspective as because the due date has not been specifically determined. Without determination of the due date, the issue relating to default in payment of rent cannot be decided. It is submitted as held in by the Honorable High Court in Tushar Kanti Day. So, determination of factual position as to when the rent becomes due necessary before giving a finding as on whether a
So
tenant-
why the appellate court could not decide?
My lord,
Why the appellate court couldn't decide?
no, my lord, that part
Whose
lordship,
burden it is for due date?
It's a landlord, Lordship.
So you should be happy if there is no evidence. You want that evidence of the landlord to be given? I'm asking.
No, not
Then-
with regard to that, Lordship.
Then why you are bringing that issue? I'm not going to set aside that they are, but I'm asking the civil judge to decide. He has to decide on the basis of this material and why the bona fide requirement issue has been removed. By the trial court, the first appellate court did not decide the speak.
That's not
Hello? Anything else?
Just point out. But
Why? We have let the civil judge to decide. Why should I decide any further?
yes,
Sir.
Lordship.
otherwise, sir, default manner, there is overwhelming evidence on record that even if for the ones that they've made,
Do
use,
you
that is
want
not the
this
pre-order.
court to come up and say that there are overwhelming evidence?
No, transport.
Who is the trial? Who is the landlord? You want that? I can decide that, but I'll have to call for the records. And I'm not being, I won't be sitting from the first week of June in this paper.
My lord, so far as the findings on default, my lord, the entire judgment goes and he decides.
Actually, the entire judgment goes on directing the first appellate court to decide afresh
What on the basis of whatever
on
is
the whatever materials are
decided on
available.
the-
Unless they file an application under order 41 rule 27, the question does not arise
Exactly.
about all
And
this.
in fact, at page 106, my lord, the trial court had rejected that prayer because they've taken time off.
Yeah.
So on the basis
So
of all
if they have rejected, that they are required to file an order 41 rule 27, they file it, then the court can very well, the first appellate court can look into those evidence and call for the NJ case. Why? The trial court should be burdened with that and fixing all this. Yes, we cannot do so, being a second appellate court, but the trial court can very well look into the first appellate. Leho. This is an application under 115 of the Code of Civil Procedure 1908, challenging the order dated 10/6/2022, passed in title appeal number 6 of the 2018 by the Court of the Civil Judge number 2, Kamrup Metro at Guwahati, whereby the learned first appellate court remanded the suit back to the learned trial court to decide afresh the entire suit. At the outset, it is very pertinent to mention that the dispute in question is a dispute between is a landlord-tenant dispute coming within the ambit of the Assam Urban Area Rent Control Act 1972. Taking into account Section 8 of the said Act of 1972, Agote Act of 72. Taking into account Section 8 of the said Act of 1972, whereby a further appeal is not provided against a appellate order, appellate judgment and decree passed by the in first appeal, and thereby the application of Order 43 Rule 1U and Section 104 being prohibited, of the code being prohibited, the instant application is taken up for consideration under Section 115 of the code. This court have duly taken note of that the petitioner herein had instituted a suit being title suit number 20/2010 seeking eviction of the plaintiff, of the defendants, on the ground of defaulter in payment of rent, as well as on the ground of bona fide requirement. The learned trial court, by the judgment and decree dated 27/12/2017, decreed the said suit in favor of the plaintiff, the petitioners herein, on both counts that the plaintiff was entitled to eviction of the defendant on the ground of defaulter in payment of rent, as well as also on the ground of bona fide requirement. The respondent herein, who was the defendant, filed an appeal before the court of the civil judge number 2, Kamrup Metro at Guwahati, which was registered and numbered as title appeal number 6/2018. At this stage, this court finds it very pertinent to observe that there was an application filed in the trial court by the defendant to produce certain, for calling the records of certain NJ cases. The said application was rejected, was allowed, and
they did not take steps for 4 consecutive days.
And was the said application, though allowed, the defendant did not take steps on 4 consecutive occasions.
Lordship, that is not in record, Lordship.
Order is not there.
106.
Had not taken steps on 29/9/2016, 16/11/2016, 22/2017, for which the learned trial court, by an order dated 8/3/2017, decided to proceed with the suit without waiting for the records of the NJ cases. Next. The appeal upon being the appeal, that is title appeal number 6/2018, was heard by the learned first appellate court. That is the court of the civil judge number 2, Kamrup Metro at Guwahati. The learned first appellate court, by the impugned order dated 10/6/2022, remanded the suit back to the trial court on the ground that the learned trial court proceeded with the case, debarring the plaintiff from calling for the remaining NJ records. And as such, direction was given to the trial court to decide the case afresh after going through the NJ records filed since the month of February 2010. In that process, the learned trial court not only set aside the decision in respect to the issue based on defaulter in payment of rent, but also set aside the issue based on bona fide requirement without even touching on the said issue of bona fide requirement in its observations. The said aspect, in the opinion of this court, grossly violates the mandate of Order 41, Rule 31 of the court. During the course of the hearing, this court had also inquired with the learned counsel appearing on behalf of the respondent, who was the appellant in title appeal number 6/2018, as to whether any application under Order 41, Rule 27 was filed, to which the learned counsel submits that to his information, no such application was filed. Be it as it may, this court, having taken note of the above material, is of the opinion that the learned First Appellate Court grossly erred in law in remanding the suit back, and the same is also contrary to the provisions of Order 41, Rule 24 of the court, inasmuch as the learned First Appellate Court ought to have decided the suit on the basis of the materials available on record. Accordingly, this court therefore sets aside the order dated 10/6/2022 and directs the learned First Appellate Court, that is the Court of the Civil Judge, number 2, Kamrup Metro at Guwahati, to decide the said appeal, being titled Appeal number 6/2018, on the basis of the materials available on record and in consonance with the provisions of Order 41, Rule 31 of the court. Taking into account that both the parties are duly represented, this court directs the parties to appear before the learned First Appellate Court on 10th of June 2024. On the basis thereof, the learned trial court, on appearance of the parties by the learned the appearance of the parties, the learned First Appellate Court said proceed with the disposal of this appeal in accordance with law, and taking into account that the suit was filed in the year 2010 and almost 14 years have passed by, an attempt shall be made to dispose of the said appeal within a period of 8 months from the date of appearance of the parties.
Lordship, and one more thing, if required, I'll file an application under 41 Rule 27. That also may be recorded.
Why should I?
No, Lordship,
That is your lookout.
no, because what?
The observations made herein above shall not preclude the petitioners, the respondents, to take such steps otherwise available under law.
I'll your paper.
Hmm.
Particular appellant here in S20 have filed a suit for partition. The suit was dismissed on the ground that there was an agreement between the family members of the plaintiff and the brothers that the land of their father will go to the mother. But that was not disclosed at the time of filing of the suit, and the court held that the plaintiff has not approached with clean hands.
Where the substantial question of law, whether in absence of a registration of any deed of relinquishment, the finding of relinquishment of the shares in the family property by the plaintiff is a perverse finding, based solely upon the evidence. What is that?
Plus, the evidence is that there was an notarized agreement between the family members that after the death of the father of the plaintiff, the defendant, the suit land will go to the mother, and thereafter the mother will give it to the one of the brother of the plaintiff. It was not registered, it was only a notarized settlement.
So,
and now,
isn't that backed with an oral partition? Isn't that document backed with an oral partition?
No, Lord.
There's no oral partition. No. Why will he do it? Why will somebody issue that document? There has to be a backing with the oral partition. Otherwise, why will he do it? Tell me.
But if that document was exhibited by the defendant.
Understood. But that document is exhibited to say, they must have 100% said that this is a follow-up document pursuant to an oral partition.
Only orally, your lordship, the land was gifted to the one of the brother of the plaintiff.
Whether it was gifted? A person not taking a share, whether the brother of the plaintiff had a right over the land or not. So he is not accepting a share. The plaintiff, having not accepted a share, and say that, okay, he will get it. Couldn't that again a follow-up of the oral partition?
But the plaintiff had not relinquished his right.
Why?
He was claiming 1/4 of the share. But the mother of the plaintiff, she has executed a document, an affidavit, wherein she has deposed that the plaintiff has taken 1.4 lakh from the mother, relinquishing his right. But that affidavit was not true. Now, as per my latest instruction, the mother is now trying to mediate between the brothers, and talk is going on. And on the next day, the mother and the brothers will appear.
Let's have it on 5th of June. At the request of Mr. H.K. Buragwai, the matter is sent to be discussed on 5th of
Please,
Hmm.
my lord, as per the direction of the lordship, I have already completed the submission at 10 o'clock early morning.
Yes.
For that, the substantial question of law is whether the testimony of Peter number 4, namely Dr. Zakir Hussain Laskar, the effect that the plaintiff number 1, namely Harunur Rahman, on his examination was found suffering from schizophrenia, having 40% disability at the time of examination, that is on 21/4/2011, would affect the validity of the sale deeds executed by the said plaintiff number 1 in favor of the defendant number 1, namely Saifur Rahman, in the year 2001 and 2006, and if not, whether the judgment may be passed
No.
by the court. So,
The instant appeal is admitted. This is an appeal under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 19/12/2023, passed in title appeal number 02 of the 2014 by the Court of the District Judge Karimganj. The instant appeal is admitted by formulating the following question of law: whether the learned court below were justified in decreeing the suit. The suit was decreed, na?
the suit was decreed.
Decreeing the suit in favor of the plaintiff without taking into consideration the evidence of PW4, that is Dr. Zakir Hussain Laskar, to the effect that the plaintiff number 2,
Plaintiff number 1, my
plaintiff number 1, as on the date of the his examination, as on the date of the examination of PW1, PW4, that is on 21/4/2011, was suffering from only 40% disability, and the documents which were executed by the plaintiff number 1 in favor of the defendant were of the year 2001 and 2006. That's it.
Yes.
This is
And that perversity that your lordship had told me on that day.
I think this is the purpose.
Yes, that is the purpose,
This is the perversity.
my lord.
You should notice, making it returnable by 6 weeks. Steps be taken by way of registered as well as usual. The registry shall call for the records of both the trial court as well as the first appellate court. This is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908. I've heard Mr. A. Sattar, the learned counsel, appearing on behalf of the petitioner, and Miss D. Bormon, D. Bormon, appearing on behalf of the respondent number 4, 5, and 6, opposite party number 4, 5, and 6. Take appear 4, 5, and he's there, na?
I will give the copy.
He's appearing, na?
Yes, sir.
4, 5, and 6. This court issue notice making it returnable on 24th of June 2024. Steps be taken by the applicant within 3 days by way of registered and usual upon the opposite parties number, opposite parties 1 upon the opposite parties. Full stop. As regards the opposite party number 4, 5, and 6, Ms. D.D. Bormon duly appears, and extra copy of the instant application be served upon her within 3 days. This court, upon hearing the learned counsel appear, has there any execution application filed?
No, as of now, not fine. As of now, not.
Taking into account that there is no execution application filed till date, this court shall await the service upon the opposite party number, opposite parties. However, it is made clear that if any execution for application is filed, the applicant would be at liberty to mention the matter for if any execution application, if there is any threat. So taking into account that this court have admitted the accompanying second appeal by formulating a question of law, and the records have duly been called for, this court states the judgment and decree dated so and so, passed by the so and so, till the next date.
1912.
I Now coming back to the facts involved in the instant case, it would admittedly be seen that on the basis of an order dated 7/8/1986 issued by the Commissioner, Guwahati Municipal Corporation, land measuring 59 bighas, 0 kata 10 letter, was requisitioned by the Deputy Commissioner cum Collector by an order dated 22/10/1986, which included the lands of the petitioners for setting up of the bus terminus. The said bus terminus was constructed and completed in the year 1988. The construction of the bus terminus was permanent in nature, and by 1988, it was undoubtedly clear that the bus terminus would be a permanent feature. Taking into account the judgment of the Supreme Court in Grahak Sanstha Manch, Supra, the respondent authorities could have gone ahead with the process of requisition for immediate necessity of taking possession of the land till acquisition proceedings could have taken up, as such process of acquisition are time consuming to a certain extent. But the materials on record do not show any rationale or reason why the land in question was kept for decades under requisition. As already stated, the respondent authorities in the instant proceedings continued to keep the land in question under requisition, and it was only in the year 2011 steps were taken for acquisition. In this process, more than 25 years had elapsed. It is the opinion of this court that since any material produced before this court justifying why the land was required to be kept under requisition for such a long period, the continuance of the requisition was nothing but a fraud on the powers conferred upon the respondent authorities, as well as a colorable exercise of the power. In addition to that, such actions on the part of the respondent authorities would amount to violation of Article 300A and a case of lawlessness as observed by the Supreme Court in D.K. Ravichandra Sutra. It is the opinion of this court that even without considering the legality or validity of the communications dated 29/3/2004, or even the order dated 30/11/2005, the act on the part of the respondent authorities to continue with the requisition for a period of 25 years was unwarranted and a colorable exercise of the power. This therefore answers the first point of determination. The question about what relief the petitioners are entitled to shall be discussed while deciding the third point for determination. Accordingly, on the basis of the above, then as regards the acquisition, this court held. Let this court now consider the second point for determination as regards the validity of the acquisition proceeding. At this stage, one needs to take note of that by virtue of the provisions of Section 16 of the Act of 1894, pursuant to the award being passed and the possession being taken, the land vests upon the state. This court also taken note of that there is no challenge in the present proceedings against the said acquisition insofar as violation to Section 4 or Section 6 or Section 11 of the Act of 1894. The ground taken to challenge the acquisition proceedings is that the acquisition so carried out in respect to the land in question was in violation to the order of status quo passed by this court in WPC number 2300/2010. This court had duly taken note of that in WPC number so and so, though there was a status quo order as regards the land, was passed on 9/4/2010, which was further extended by an order dated 5/5/2010 till the next date, but there was no date fixed. The matter was not listed for years. With due respect, this court finds it opposite to observe that extending a status quo order till the next date without fixing the date renders the interim order ineffective, inefficacious, and unproductive. Be that as it may, it is also relevant to observe that the status quo order so passed was in connection with the challenge made to the order dated 6/3/2010. The said status quo order did not preclude the respondent authorities to acquire the land if the statute permitted to do so. Under such circumstances, the question of interference with the acquisition proceedings on the ground of existence of a status quo order in the opinion of this court would not be proper, since any violation to Section 4, 6, or 11 of the Act of 1894 being made out by the petitioner. The above therefore decides the second point for determination. Accordingly, on the basis of the above analysis and determination, the third point of determination is decided in the following manner. All the 5 writ petitions are disposed of with the following observations and directions. This court holds that the continuance of the requisition of the land in question for a period of almost 25 years, that is from 22/10/1986 to 5/8/2011, was unreasonable and arbitrary. The said requisition so continued for more than 2 decades is nothing but a fraud on the power conferred upon the respondent authority and also amounts to colorable exercise of power. The continuance of the requisition of the land in question also violates the mandate of Article 300A of the Constitution. However, taking into account that during the pendency of the writ proceeding, the land in question have already been acquired, thereby the requisition had come to an end. No directions can be issued against the illegal continuance of the requisition. Be that as it may, this court grants liberty to the petitioners to file an application before the District Commissioner Kamrup Metro if aggrieved by the inadequacy of the requisition compensation. This liberty has to be exercised within 6 weeks from the date of the instant judgment. The District Commissioner Kamrup Metro shall be at liberty to either accept the claim so made or make a reference to the court of the learned District Judge Kamrup Metro within a period of 6 weeks from the date of submission of the application, bracket if any. This court finds no reasons to interfere with the acquisition so carried out in respect to the land in question, for the reason already above mentioned. Be that as it may, this court makes it clear that a persons interested in respect to the state land would be entitled to the compensation. The withholding of the state compensation on the ground of pendency of the instant proceedings, that too when there was no stay, was completely uncalled for. as neither the concerned respondent have tendered the amount to the person interested in respect to the state land in question, nor have deposited the same in the court, the same amount shall carry interest in terms of section 34 of the Act of 1894, till the said amount have been duly tendered to the persons interested. Taking into account that during the pendency of the instant proceedings, the acquisition proceedings were initiated and culminated, the person interested, that is the petitioners herein, are given the liberty to file an application under section 18 of the Act of 1894 before the District Commissioner, Kamrup Metro, if aggrieved by the inadequacy of compensation, and the said application has to be filed within 6 weeks from the date of the instant judgment. The District Commissioner, Kamrup Metro, shall be at liberty to either accept the claim so made or make a reference to the court of the learned District Judge, Kamrup Metro, within a period of 6 weeks from the date of submission of the application, if any. In view of the above findings in respect to the continuation of the requisition for almost 25 years, and holding it to be unreasonable, arbitrary, and a colorable exercise of power, this court is not inclined to go into the legality and validity of the orders dated 30/11/2015, 1/11/2007, 30/11/2005, 1/11/2007, and 6/3/2010, as the same loses significance. The claim of the petitioners in WPC number so and so is a claim. It is your case, no? Primarily between the petitioners of the said petition and the private respondent as to who would be entitled to the requisition amount, and whether the private respondents in the said petition had the authority to transfer the land to the petitioner number 6 to 31 in WPC number so and so. These disputes, being disputes which are civil in nature, the same cannot be adjudicated in the instant writ proceeding. Be that as it may, the petitioners in WPC number 1925/2009 are given the liberty to file an application before the District Commissioner, Kamrup Metro, seeking a reference as regards the entitlement to the compensation, both requisition and acquisition compensation. The said petitioners also would also be at liberty to additionally seek reference on the inadequacy of the compensation in respect to the requisition compensation as well as the acquisition compensation. The liberty to file the application has to be exercised within 6 weeks from the date of the instant judgment. This court further directs the District Commissioner, Kamrup Metro, to the effect that in the circumstance the petitioners in the instant proceedings file applications seeking reference on the basis of the liberty so granted herein within the time stipulated, that is 6 weeks from the date of the instant judgment, District Commissioner, Kamrup Metro, shall forthwith and not later than 6 weeks therefrom make a reference to the court of the District Judge, Kamrup Metro. All interim orders which have been passed in the writ petition cease to exist with the passing of the instant. Mr. Nayak, you are appearing in this matter. Just put your name.
My lord, one I want to point out, my lord.
Yes.
Installment already given, my lord. Earlier occasion, requisition compensation to installment given, my lord.
Whatever may be. You want,
Yes.
you don't want, that is not my
Yes,
lookout.
we want, but
You see, it is not the question of requisition compensation. It is the question of an illegal continuance of a possession. It may be a case of mean profit.
Yes.
You may be entitled to more than that.
Yes.
You may ask for that or you may
Yes.
not. That is your lookout.
we pray for, my lord. For him.
Ask on your own,
I would like.
the Pina Act. Huh? Yeah, passport. Yes, what is it?
My lord, regarding service, my lord, 2524, my lord, 5, respondent 5 and 6 have filed their wakalatnama, my lord. And in fact, my lord, on 15/5/2023, they were given liberty to serve the notices on the council appearing before the trial court. That is how we had effected the ducty. Wait, put your tax.
What is the challenge?
What has happened here? I filed this suit alleging a particular release date to be false. An application was filed to send the document for forensic examination. Strangely, my lord, what was done was those executed documents from the safe custody of the court was given to the lawyer appearing for respondent number 5, who took those documents back home, my lord, kept them for a month or so, and then he claims that he had posted them directly to the FSL office, and the postal department said that those disputed documents are
Whose documents were there? Your.
the document that I tell you.
You submitted those documents.
So they submitted that document. They submitted that document, my lord. An order was passed for handwriting examination. The order said defendant to take steps. Now what they did was they took the documents from the safe custody. They handed it back to the defendant number 5. Defendant number 5 keeps it with him for like a month or so, as per his own version. And then he says, I was not well, therefore I kept it with me for a while. And then I sent it by post to the FSL department, my lord. And
But
then
in the court marked there, these are the signatures, these are the question signatures, these are the
there is an indication in that particular notice, my lord, but the court did not send it directly. The court instead handed it over to the defendant. And defendant says he sent it to the FSL by way of registered post. Postal department says all these documents have been. No, the manner in which it was done. Therefore, we pointed out to the court that this calls for an inquiry as to how can these disputed, these sensitive documents be handed back to a party, and how can the party take the initiative to send it to the
why did they produce those documents?
They produced
Why?
the document. My specimen signatures were
How
taken.
did they produce those documents?
They only relied on that release sheet, my lord. I produced one document for admitted signature. Additionally,
Your signature, your document which you produced
Yes.
is also lost.
is also lost. Everything, the specimen signatures are also lost. The disputed question document is also lost.
Now, disputed question document they produced.
They produce.
How?
They produce the deed.
Now how? But on the basis of orders passed by the court?
Yes, yes.
Is it an order passed on order 11 rule 14?
No, my lord. That is not a part of record, my lord. But if your lordship sees the initial order at page 61.
Yeah. No, how did the court do send it? The court has to mark the document that this is the signature, which is the question, the question signature.
Yes.
Where is it marked? Which order?
My lord, that order is not there, but
Yeah.
if your lordship sees page 95, that is the notice that was addressed to the director FS
By
by the court.
this is
This is the note.
it was done to the court.
My lord, the notice is signed by the court, and but the court did not send it. Page 120, if your lordship take their explanation to the entire, it's an admitted position, my lord. 120, if your lordship takes up. This is the objection that they filed.
Yes.
Paragraph 5. Somewhere from the middle, my lord, will find the defendant accordingly took steps and deposited notice along with the original documents before the honorable court. The
And
honorable,
whose is this? What are the documents? Agreement for sale is your document,
yes,
and two power of attorneys are your documents.
yes.
Your
And
documents are also lost.
16/8/2013, that's the disputed document. That's the question document.
Her signature on the document are encircled with black pencil to enable you to identify her signatures easily, especially in those documents where appearing with other signatures. Yes,
Lord, all these documents we are only relying upon for the learned friend. All these documents that were lost, my lord, as far as the question of inquiry,
agreement for sale also.
all these documents, and out of these 4 documents, 3 they are admitting that they have signed. There is no dispute regarding this. Out of these, my lord, there are 4
No,
documents.
no. What has happened to these documents?
My lord, the result of the inquiry is there at page
No,
112.
first of all, why did you send it?
Because there was an order, because there is no other method, my lord, because it was an order from the court itself to send the document in the council.
No, you
That-
were only
that is
asked
there
to
at page
take
60.
immediate step.
Yeah.
Directed hereby to immediate step for sending the signature.
And my lord, the documents were not lost from Tezpur. The documents were lost at Guwahati. And the documents were lost not by me, but by the postal department. The inquiry was held by the Department of Post. Lordship will have for a moment page 112. Because the court, my lord, directed the postal department to submit a report. Repeated orders were sent, and this is the letter, my lord, 6/12/2019. If I may read it. Is to intimate that the registered article number so and so dated 24/1/2019 booked at Tezpur Head Post Office was consigned to computerized registration center, Guwahati Railway Mail Service by bag number so and so by computerized registration center, Tezpur Railway Mail Service dated 24/1/2019. The bag was closed in transit bag for Guwahati Railway Mail Service and dispatched to mail agent Guwahati RMS with entry at serial number so and so by Tezpur RMS 2.
This is of 2019.
Yes.
And after what happened?
Thereafter, my lord, because in this letter, my lord, it is clearly mentioned the inquiry was made into the
You are
case.
appealing?
I am appealing to response number 10.
What is that?
Response number 10 is one of the parties.
Please pro forma otherwise.
Where is the? You are a CGSE? You are? You are not. Where is Miss A. Gayan? You find her? There are.
The lordship sees, my lord, in the letter. In this connection, inquiry was made into the case and the erring official has been identified. The departmental action has been initiated against the official as per rule. This is the report that is submitted by the Department of Post. And the transit bag was lost from Guwahati. In fact, my lord, what my instruction is that the official concern was later even called to the court.
Now, what has happened with this postal department? Anything?
Nothing more. Matter ended there, my lord. Actually, what has happened, my lord, informally, my instruction is that the hearing official was called to the court. There is no specific order regarding that. He admitted that there was some mistake. He was on the verge of superannuation. The court, my lord, out of sympathy or whatever that may be, decided not to pursue the matter because the department intimated that it is proceeding against him. The department indicated that it is proceeding against him. That is what is indicated also in the letter of that is at page 112. So the department admitted that the fact that it was misplaced and it was misplaced here at Guwahati, that is the responsibility of that particular official of the postal department. What they are trying to do, my lord, is to somehow
the
go in
inquiry upon 5 and 6, why is it required? Because it was the fault of the court. The court should not have given it to the 5 and 6. The court should have asked them, asked the defendant to kindly deposit and it should have been sent from the court. But why did the court make an order to the effect?
Well, the court did not make any order specifically.
Yes,
that is the order at page 60, 61. Man.
Page 61, it categorically says directing the defendant number 1 to take steps. Then,
steps meaning, well,
understood, but here then one is followed by the authority or the court.
I agree. Well, it was the court's mistake. It was the paper should not have been handed to them.
Absolutely.
And well, secondly, they should not have kept it with them for a month.
That's a different thing, whether they have kept it or not.
That's
its efficacy for that. The inquiry for what? Did the court pursue that? Why haven't you sent it? In the duty of the court. It's the mistake of the court. What is the inquiry out there?
After 14/12, the date was next fixed on 18/1/2019, and on 24/1 the steps were taken.
14/12/18 the documents were collected from court, and they had dispatched the documents on 24/1/2009. That is where we sang sort of.
Whatever may be, they did not change it anything to the effect.
We don't know
whether they have done it or not, but they have sent the document, rightly or wrongly, whatever may be, with a piece of paper or not, whatever may be, they sent it. So if they have sent those documents out there, don't you think it was actually the mistake of the court?
It is the mistake of.
So if it is a mistake of the court, how can the inquiry be gone against 5 and 6 or even the lawyer? It was absolutely a mistake of the court. It is never heard of.
Exactly.
The question then. And this judge even doesn't know the thing a round circle for that. It is not how you do it. Proper training should have been given to the
All of the main difficulty is one of the main disputed document is gone. That was the main primary challenge.
But I am relying on that document. If anybody stands to gain, is the plaintiff who stands to gain. I stand to lose on because these are the documents that I am relying on. And out of those 4 documents, 3 they are admitting. In fact, my submission is that
Ganguly, I know how are you going to gain. Now you don't need, there cannot be a scientific because the signature.
Yes, but
there's the photocopy now.
Yes.
Secondly, in view of all these proceedings, you will now be granted the benefit of 63.
that That part
Okay.
is there, but the allegations of
You
tampering,
get without
etc.
the original document on record being proved, you get it. That it is 63 and it is beyond now to go for scientific appraisal.
Look, in that view of the matter, my lord, it was I who took the pain, my lord, and filed the application under Order 26, Rule 10. They vehemently opposed that that objection. They said that these documents should be confronted to the witness, the plaintiff, my lord, at the time of hearing. Their objection is also on record. So I insisted that these should be given to be sent to the FSA because I am relying on 4 documents, and out of those four documents, 3 are admitted. So in my humble submission, those 3 documents should never have been sent at all because they are admitting. The fact admitted, that was true.
No, they are sent it for need documents for purpose of signature comparison.
Yes.
How will you do that?
And as far as the 4th document is concerned, that was the release. Now, all those 4 documents are gone. And as far as page 112 shows that, it was displaced at Guwahati, and the fault lies with the postal department. And the only objective of the plaintiff, as is evident, from the order, impugned order, is a well-reasoned order, everything has been considered. It is the first set of facts. Impugned order says that, the learned trial court has found no evidence of any nexus between the counsel. That is what they are saying, that there is a nexus between the counsel and the disappearance of the document.
Whatever may be, it was a mistake by the court.
Yes, but that is not what they are saying. This
It was
there is a
mistake. The
space
court
is the
should
last.
not have. Once the document has been given for scientific appraisal and the court has passed an order, sending has to be to the court.
Yeah, should be.
It couldn't have been given to anybody else. And if the court gives it to somebody else, it is his responsibility, the court's responsibility, also to equally burden. If the court wants an inquiry for himself,
yeah, the court
Only-
did that
only
inquiry for a
the
limited
inquiry for perhaps.
the inquiry, what is there to be made out there against the court? If the court doesn't know how to send a document,
And only think, my lord, if we can later on agitate or put in key by saying that if there is an inquiry at all and some fault is attributed to them, perhaps we can rely on an
I know why you want. The moment I have an inquiry out there, there is some fault is attributed, then they cannot get the benefit of secondary
evidence, and I perhaps get the
That is
benefit
the
of that.
reason I know that also why you want that. But if mistake was of that of the
It
court,
is unfortunate.
you can't help it. And they have also, the postal department has said that yes, they have received the document, but they don't know whether those documents were inside.
What was then? Was it those documents?
You can very well question when they produce that document and put that question, you actually sent it or not, what is the proof? The observations made here by in the impugned order shall not preclude you from putting that question as to whether actually the document was sent. They will go now for 63. Once they go for 63, you can raise those objections to actually do 10%.
Can be decided at the appropriate stage. That plea can be decided at the appropriate stage. For that purpose, this should not be
That
kept.
will be taken up by the trial court. But how can this court interfere with that order? Actually, the court has said what they are not at fault 5 and court made the mistake of giving
Court interprets taking steps as to mean that the documents should be handed to them as if it's a personal search. The court has interpreted
the order should have been on at page 60 and 61 should be that the respondent number 5 and 6 is directed to deposit this amount as cost, which should be, and the head solicitor should send the report to the DS. That should have been the order. And for steps is only for the purpose of deposit of that amount.
Preparing those written up notice.
What the court did, took that amount and closed it with the petition. And it was sent later on by the respondent number 5 and 6, but handed over the papers to him for sending it. The posting should have been done through the court, not by the respondent number 5 and 6. But when the court permitted these papers to be handed over, what to do? Yes. Whatever may be special messenger, whatever they do, that's a different thing. I'm not on that. But it is the duty of the court. Court did everything. But handed over the papers back to the phone number 5 and 6 or whatever, and we look into this and send it. And they took 1 month time.
What happened during that 1 month time?
What happened is a different thing. You want an inquiry, go and for an inquiry in the criminal court. Court officials sent. They should have taken the leave from the court. Or the court should have not given it. It is not for the yeah.
Not only fall now on record on your finally apprehension. Only fall that we can identify with the retaining of those papers from 1412 to 24.
That respondent number 5 has
When
already
did the court
passed away.
put the matter for text state? There's some reference to something out here that there was no sending of this.
Yes, madam.
Where is it?
And there's the issue register, madam.
FSL had not received. Now see, the defendant number 5 and 6 have taken steps, page 130. As per the direction of the court for sending the signatures, and these were sent to the FSL. However, report from FSL has not been received by this court. After communication with the so-and-so, they had sought the receipt number and the date for verification as well. However, from the postal fingerprint, it appears that the registered consignment number so-and-so, booked at Tezpur, was received at Guwahati RMS by number so-and-so, and accordingly some articles were not traceable till date. After by the order dated demand, this court had passed an order that disclosed from the report dated so-and-so booked area which was sent to demand at demand. It further disclosed from the report that on receipt of the bag, the CRC Tezpur bag, the article with CRC Guwahati in bag number so-and-so, and they replied that they have received the state TV on so-and-so. It informed further that the Guwahati CRC will intimate the information in this regard, but further disposal of the bag and concern is not received from the CRC till date. Considering all the aspects in the light of the submitted by the senior imam, this court to find out the status of the imam to which the AR was sent, thinks it to ask the CRC Guwahati as well as the senior superintendent of AR to find out the consignment and transmit before it. It is seen that till today the report from the FSL has not been received. On perusal of the case report, it appears that after taking the specific signature of the plaintiff, so and so in a separate sheet, they were kept in the safe custody of this court. After this court had directed the defendant number 5 and 6 to take steps for sending the signatures of the plaintiff so and so to the handwriting expert for scientific investigation against her immediately. You are the plaintiff.
I'm the plaintiff.
So why do you need those 3 documents for that? The power of attorney,
Look, one power of attorney because it is going to with attorney. That was one number. The earlier 2 were admitted documents.
That is your signature. Your signature can be taken at any point of time. So that doesn't have any problem out there. Only thing may be that if that release date of a particular year, that release date, the signature of that particular year, if it is taken, it helps in making the handwriting expert report. Because with the time changing, there might be a change or the family may change. However, this report with regards to where is the postal receipt?
Yeah, the order shows that it has been submitted.
Where is the postal
94.
receipt?
It's a fact consent.
No, the receipt copies.
Yeah, page 94.
Below, my lord, it says 12.
Page 94.
Yes, yes.
What is the weight?
78 grams.
Can it be? With 3 documents. Is it possible? Can 3 documents weigh only 78 grams? Along with that, document, the notice and the better. Why should I help you any?
My friend was prompting.
Eh?
My friend was prompting the weight.
What?
Prompting the weight.
That is why I wanted to. The 78 grams can't be impossible. Anyway, what to do? Don't risk it. However, if he files an application, you will be at liberty to take that. Don't find any good reasons there. It's the fault of the court. Why you are asking him?
No, we are on the same side.
Plaintiff's attorney holder. Plaintiff's attorney holder is husband of.
That is right.
No, provided it's separate. So we've disclosed that. There's no pollution.
Now, what to do?
Your Lord will first, your Lordship will mark that the trial court has again imposed cost on me. Your Lordship will set aside that cost for it. Because it was a bona fide attempt. Okay, the document, that's number one.
This cost is in terms of section 35. Dismissing a petition, the cost.
But so provided that it's frivolous, this was a serious.
There is no
Of course,
frivolous.
the cost is minimal, my lord, but nonetheless.
Is it mentioned as frivolous?
Yes. Derail the administration of justice. That's not true.
No, that is not the observation of the court. The court is referring to his allegation.
Yes.
So the prayer of the that is his allegation.
Yes,
so the
not the
prayer of the ER to initiate inquiry at an inquiry and the Iman to derail the administration is rejected with cost of time. The cost amount to pay.
And secondly, my lord will give me liberty to discharge the presumption under the Registration Act and also.
That is your lookout. Why should you give your liberty into an application for
Will at
inquiry?
least observe that this aspect of the matter would gone into the court of trial as to whether the transmission of documents is proper.
That then will open up another.
It's in any case a matter of evidence.
Here you ask for an inquiry.
Correct.
Inquiry, this court, the trial court has come to a fact-finding inquiry on the basis of the materials already there.
But trial court, in my respectful submission, has gone wrong when it interprets to take steps is to take the documents home and send it back.
That way he was wrong. In fact, it shouldn't have. In fact, the permit, the ER was given is by the trial court made the mistake. Or the officials of the trial court made. But I don't want to put it by way of a judicial order, because if I do, it may that the judicial officer may be in trouble later with a high court order, and without hearing him, it would not be proper. It would be casting aspersion against the judicial officer. Yeah. Enough. Now that I've given you the liberty to withdraw, you have not now let me pass. It is an application under Article 7 of the Constitution, challenging the order date 5/4/2022, passing statute number 27 of the 2016, whereby the learned trial court rejected the application filed by the petitioner, who are the plaintiffs in the suit, for initiating an inquiry and also for inquiry against the defendant number 5 and 6, who are the respondent numbers. You are
5 has already passed away. I am for 5.1 to 5.4 and 6. 5 passed away.
The defendant numbers 5 and 6 in the said suit, including their counsel. So the fact leading to the filing of the instant application briefly stated are that register a release deed dated
2013. 16/8/13.
16/8/2013 is a subject matter of challenge in title suit number
27 of 2016.
27/2016, amongst others. Is it a challenge?
Yes, ma'am. Page 33.
Page 34. 34 is the prayer.
Yes.
Where is it? Release it. Challenge is the subject matter of challenge. Release it in amongst others in title suit number 27 of 2016. In the said suit, an application was filed by the defendant number 5 and 6 under Order 26, Rule 10A of the Code of Civil Procedure 1908, or short the Code, seeking scientific examination of the signatures of the plaintiff number 1, or of the plaintiff number 1, na? Release deed is of plaintiff number 1.
Sole plaintiff. Plaintiff is
There
only
are
one.
two plaintiffs. Huh?
There is only one plaintiff.
Why there are two persons at page 24?
My lord, one is the constituted attorney.
Of the signature of the plaintiff, Srimati Kamala Devi Bhantia. Bhantia, Banthia. The said application was allowed by the learned trial court by an order dated 18/9/2018. However, in allowing the learned trial court, directed the defendant number 5 and 6 to take immediate steps for sending the signature of the plaintiff to the handwriting expert for scientific investigation against the admitted signatures. It further revealed from the records that where is that notice, or that notice, where is that?
Right.
It further revealed that pursuant to the order dated 18/9/2018, the learned trial court, by an order dated 13/12/2018, issued a notice to the Directorate of Forensic Science Laboratory, Kahilipara, to examine the signatures taken on some white paper in the open court and compare the same with her signature, with the signatures appearing in the agreement for sale dated 20/12/2004, two power of attorneys executed by her dated 24/12/2012 and 27/11/2010, and the release deed executed on 16/8/2013. It was also mentioned in the said notice that to send the report in a sealed envelope to the court before 18/1/2019. Along with the said notice, a draft of rupees 2,000 in the name of the director was enclosed. Further stating that if any additional expenses was required, the same shall be paid upon submission of the bill. Surprisingly, instead of the court sending the said papers, either through the official process or through a special messenger, the trial court and its office handed over the papers to the defendant number 5 and 6. Defendant number 5 or 6, which one?
5. 14,
Defendant,
12, 8.
Huh?
14, 12, 5. 14, 12, 8.
defendant number 5 on 14/12/18 to send those papers to the director FSL. The defendant number 5 admittedly on it is an admitted fact that on 14/12/2018, one Miss Amelie Soikia had received the envelope from the office of the civil judge Tezpur and handed over the same to the defendant number 5. The defendant number 5 thereupon took steps on 24/1/2019 through registered post. And the consignment was booked from Tezpur Head Post Office by RS 445171301 IN. This aspect of the matter is seen from paragraph number 5 of the application filed by the of the written objection filed by the legal representatives of the defendant number 5 and well as the defendant number 6. Upon sending the said document, there was no report submitted by the director FSL. Under such circumstances, the trial court, the learned trial court, issued notice reminding the director FSL for submission of the report. And the director FSL, by the communication dated 15/7/2019, sought for the receipt number and the date of further verification, as they could not trace out those documents sent for examination. It further reveals from the impugned order that there were various inquiries being made with the Department of Post also. And from the said documents, it appears, from the said inquiry, it revealed that it was on account of the fault of the Postal Department that the said consignment, said document, which were sent, that the consignment bearing number RS 445171301 IN dated 24/1/2019 could not be traced out. It is under such circumstances alleging that there was certain illegalities being committed by the defendant number 5 and 6 along with their counsel. An application was filed by the plaintiff seeking initiation of an inquiry. This application was registered as petition number 442/2020. To the said application, a written objection was filed by the LRs of the defendant number 5 as well as the defendant number 6. By the impugned order dated 5/4/2022, the said application was rejected, and it is under such circumstances that the present proceedings have been initiated. This court have duly taken note of the order passed, impugned order passed. And from the impugned order, it does not reveal that there was any fault, that does not reveal that the learned trial court had erred in law or had committed any jurisdictional error in rejecting the application seeking an inquiry. Apart from that, this court further finds it very pertinent to observe that the learned trial court ought not to have handed over the documents to the defendant to send it to the director FSL. Rather, it should have been sent by the court below, by the learned trial court, through its office or through a special messenger. Be that as it may, the said consignment, the document, the said consignment bearing number here to RSA2 have been lost, could not be traced out by the postal department, which is admittedly seen on record. Under such circumstances, this court is not inclined to interfere with the order dated 5/4/2022. This court further takes note of that by an order dated 8/6/2022, the further proceedings of title suit number 27/2016 was stayed. The said order stands vacated, and the parties who are duly represented are directed to appear before the learned trial court on 15/6/2024. Before concluding, before parting with the record, this court finds it very relevant to observe that the observations made in the instant order, as well as also in the impugned order dated 5/4/2022, shall not preclude the parties in the suit to take such pleas in respect to those documents which are otherwise permissible under law. Yes.
May I please, Your Lordship? I was telling in order passed by the Munship Amin Dollar. It's page number 49.
Where?
Page number 49.
49.
Where was being debarred from participating in the suit after LTPS. Before going to the entry of the Lordship.
You filed your written statement?
Yes, sir.
Then?
Sir, before going to page number 40.
What is the status?
LTPS. Step before preliminary yet.
Huh?
Step before preliminary yet.
Preemptory hearing.
Preliminary.
Preliminary. Then
Then Lordship, and this page number 40
after filing of the written statement, what are the stages in the suit?
will SDPF, the before preliminary hearing, the issues are framed.
Before that,
Uh,
issues. Issues have been framed.
Framed.
Now you have not been asked to,
So you have to give list of witnesses, Lord.
and the court have stopped you.
Lord.
Why?
Page number 40, Lord. Page number 40, Lord. So 40, this is
What is the
What is the
cost of
difference?
area is mentioned on the
issues has been
previous
framed
order
today.
with
After that, Lordship 40, then again Lordship 41.
40.
40.
40. Where is it? Yes, the parties are represented. Defendant he has to pay ₹2,000, and the draft issues have also not filed draft issues. This issue has been framed today. So and so for SPPA.
Yes.
1/11/2020.
And 1/11/2022, the
Plaintiff is presented the list of in filed defendant 57. Plaintiff side so 16 6 and 11 to 14 furnished copies so and so forth. Yeah.
I'm prejudiced by the order, page number 44.
Plaintiff is there, defendant is there, the suit will be there, party against the other, unnecessary order of defense.
Lordship, here,
Yes. Wait. Then what order? 8/2/2023. So today is the petition filed by the and yes, what do you have to say?
May you, Lordship, before going to the legality and the merity of the order, merits of the order, then the petition filed by the petitioner. A brief facts about the conduct, the in gross negligence they have given, they have in prosecuting the appearance before the Lordship, your Lordship. I have filed an affidavit in opposition, along with the orders from the date of appearance, your Lordship. After receiving summons, they have filed, your Lordship, after 4 years, 3 months, WS has been filed. Each and every alternate day, your Lordship, they used to remain absent. On earlier 2 occasions, your Lordship, suit was proceeded expertly against them, and court has given a liberal applause to give them a WS. On earlier 2 occasions, this is the 3rd time, your Lordship. And earlier also, cost was imposed upon them. They have till today, they have not submitted the cost subject to the filing of written statement. Written statement has been filed, but cost has been imposed by the learned trial court, but they have not given. And this is the 3rd time, your Lordship.
How much is the cost?
Only 2,000, your Lordship.
the way actually,
Only 2,000.
After that, Lordship, after the expertise, Lordship, I went to posit it, but the learned trial court said that because expertise is there, they refused to take the Hajira take up any money.
Ready to deposit the cost? You are ready to deposit the cost? What? Which court is this?
Munsi.
I mean,
what is wrong with this judge? Okay, now tell me, expertise is done under what provision?
Order 9, Rule 6.
Order 9.
That at the time of hearing, that illegality has been, I admit, your Lordship, go
It
to
was
the order 6.
for filing objections, and on that day, the court says it will go proceed.
Yes.
Let them go. Let the court pass that order under order 11 Rule 14 or order 16 Rule 6. Let the court pass those orders. What is all these things that the filing objection doesn't appear, then you proceed ex parte? Doesn't this judge doesn't know a head or tail about what you see? Yes, you're depositing
Your
the
lordship, seeing the conduct of the
conduct,
So,
whatever
Your Honor,
conduct, whatever
Your
conduct, the court has to know the CPC to take what is required to be done. If he had taken 4 years for filing written
Yes, Your
statement, it is a shame on that court that how did the authority, the court permitted him to filing written
Yes,
statement for 4 years
Lordship,
when
4
he
years.
has not approached it. Wait, it is for the court. It is the responsibility of the court. It is the mistake of the court. How can these
Your
type of
Lordship,
things happen?
they appear
If they don't file on the date on filing of the application under order 16 rule 6 or order 11 rule 14 and has fixed for objection, the court should have passed the order. That they have not present, there is no objection, will file it. What is this proceeding ex parte against them and asking, don't even, what is the concept of ex parte? These people, they don't understand. Ex parte is a proceeding that you need, you see, order 9 rule 7. Order 9 rule 7 is a proceeding by which when you file it, if you are successful, you can put the suit back to the state on which date the court has proceeded in his absence. That's the state. Now he is not asking for that. He wants to appear on that day, and on that any day he can very well appear. No court can stop him. The proceeding does not mandate. These people, they don't have this judgment of Arjun Singh, which makes it very clear. 64 Supreme Court, it says it is the order 9 rule 7 is only necessary when you require to put the clock back to that position when the court proceeded judicially in absence of him. That's it. Hello. Let me read. Mr. P. Sharma, the learned counsel appearing on behalf of the petitioner, and Mr. P. Chaudhary, the learned counsel appearing on behalf of the respondent. This is an application under Article 227 of the Constitution challenging the order dated 8/2/2023, whereby the learned court of the Munsif, Amrup, Aminga, had rejected the application under Order 9 Rule 7 and fixed 5/4/2023 for necessary orders on the petition number 2780 and 2781, as well as for payment of costs. This court finds it very pertinent to take note of certain facts which led to the filing of the instant proceeding. From the perusal of the materials on record, it reveals that the respondents herein had filed as plaintiff has instituted a suit being titled suit number 15/2019, challenging, seeking a declaration of their right title and interest in respect to the scheduled land declaration that the so-called handwritten paper dated 16/7/1972 recording the expression of the partition shown in had filed a suit seeking declaration of their right title interest, confirmation of possession as well as an injunction. The record clearly shows that on 18/6/2022, the respondent, the petitioner herein, who was the defendant, had submitted the written statement along with cost. It is further seen that on 10/8/2022, the plaintiff had filed a draft issue, and on that day, the issues have been framed, and the case was fixed on 1/11/2022 for steps before preemptory hearing. On 1/11/2022, the plaintiff filed two applications. One is an application under Order 16 Rule 6, and the other is an application under Order 11 Rule 14. On the same date, the case was fixed for 21/12/2022 for filing objection, if any. However, on 21/12/2022, none has appeared on behalf of the defendant, and the learned trial court fixed 8/2/2023 for necessary orders on petition number 2780 and 2781. On 8/2/2023, the defendant, that is the petitioners herein, filed an application under Order 9 Rule 7 for permitting the petitioner to participate in the said proceeding, assigning the ground that it was on account of the mistake on the part of the counsel in noting down the date the defendant could not appear on 21/12/2022. This application was rejected by an order dated 8/2/2023, and it is under such circumstances the instant proceedings have been filed. This court finds it very strange to take note of that the court finds it very strange to take note of that the learned trial court completely failed to consider as to when a suit has to proceed ex parte, and what is the reason why a suit should proceed ex parte. It is well settled principle of law that in a judicial proceeding, the proceedings are required to be held inter partes. However, if the defendant failed to appear on a date fixed for hearing, the court has to pass an order to proceed ex parte. Else, this order, strictly so and so, is an administrative order. It is an order in more like an administrative order, in as much as for the court to pass an order, for the court to further proceed to the next stage, the said order is required. An application under Order 9 Rule 7 is required to be filed when the defendant, having failed to appear on the earlier date which was fixed for hearing, explains the reason why the defendant could not participate in the hearing, so that the clock can be brought back to the stage on the date on which the suit proceeded ex parte against him. An application under Order 9 Rule 7 is not conceived of when the defendant chooses to appear from the stage at which the suit proceeds. The suit is fixed, unless the defendant wishes that the suit be brought to the stage on which the date was fixed for proceeding ex parte. Under such circumstances, in the backdrop of the above, if this court duly takes note of the facts involved, it would be seen that there was at the state of steps before preemptory hearing, when two applications were filed by the plaintiff, one under Order 16, Rule 6, and the other under Order 11, Rule 14. The said applications were not fixed for hearing, or even the suit was not fixed for hearing. Under such circumstances, the court would not have passed an order of proceeding ex parte. If the court found it that there was no objection filed on that day, the court could have been at liberty to pass an order allowing or dismissing or disposing of the said application so filed by the plaintiff. And nothing more. However, in the instant case, the court rejected the application under Order 9, Rule 7, thereby forbidding the petitioner who are the defendants in the suit to participate in the suit, which is absolutely unwarranted and completely foreign to the provisions of the Code of Civil Procedure. Accordingly, this court therefore sets aside the order dated 8/2/2023 and thereby directing the learned trial court to permit the petitioner, who are the defendants in the suit, to participate in the suit. This court further takes note of that by an order dated 16/6/2023, the further proceedings of title suit number 70 of the 2022, pending in the court of the learned Munsif Aminga, was stayed. The said order stands vacated, and the parties are directed to appear before the learned trial court on 3/6/2024. On the said date, the petitioners herein, who are the defendants, would be at liberty to file their objection to the petitions so filed, being petition number 2780 and 2781. It is made clear that if the petitioners herein, that is, the defendants, fail to file their objection, the learned trial court shall be at liberty to pass such order as deemed fit on the such petitions. In addition to that, the petitioners herein are also directed to deposit the costs which Mr. P. Sharma, the learned counsel appearing on behalf of the petitioner, undertakes to do so on the next date so fixed. With the above, the petition stands. This court have duly taken note of the office note dated 3/5/2024, and it is seen that the service upon the respondent number 1 to 3 is not complete. It's the matter on 24/6/2024 on an update as regards the status of service upon the respondent number 1, 2, and 3. The interim order passed earlier shall continue till then.
Try to contact with my client. So I got the one of the relative. So he said that he also could not contact. So he said that
Withdraw the appeal.
yes, I want to the appeal. Because appearance of the internet are dependent number of time, but ultimately I failed to check. I also given the
Appellant died.
appellant also died.
When?
My lord, that is why my client.
When?
In the meantime,
In the meantime, when? Any idea?
Long back they died as per my information.
because they are not
They are
there.
appellant
I
side.
learned it.
And in my respondent side also number of people died. So
Because not less than
No, I don't want to make it as a withdrawal. I like to abate that. I'll abate that. Because if I withdraw your appeal in this manner in respect of a dead person, tomorrow the bar council
well, I took that just from but not the
understood. Therefore, let me abate that.
Yes.
It has been brought to the notice by the councils appearing on behalf of the parties that long back various appellants long back many of the appellants had expired. The records also show that many of the defendants have also, the respondents have also expired. It is also seen that no step was taken by the appellant in spite of orders passed by this court. Since 2017. Taking into account that the decree which have been passed is a non-severable decree, the instant appeal stands abated and accordingly stands closed. The registry shall return the LCR to the courts below. None appears on behalf of the appellant on call. Since 2013, no application also has been filed for substitution. As is available, as could be seen from the office note. It appears that the appellant have lost interest in the instant proceedings, for which the instant appeal stands dismissed for non-prosecution. The registry shall return the LCR back to the trial court, to the courts below. Service complete. And LCR received. Service is complete as well as the LCR has been received. This is the man need for hearing any judicial court. (24) Here, response number 1 to 4 is appearing. About performer response number 5.
Hello, Chief.
Sako. Mr. P.K. Bhagavati, the learned counsel appearing on behalf of the appellant, submits that the respondent number 5 is a performer respondent who have neither participated in the trial nor in the appeal. He submits that the performer response number 5 may be struck off. In that view of the matter, the name of the performer respondent number 5 is struck off. It is also seen that the respondent numbers 1, 2, 3, and 4 is being represented by Mr. T. Bharadwaj.
Except response number 4, 1.
Okay.
Huh?
I am appearing for 1, 2, and 3.
Oh, who about 4?
4 is some other company.
Over exchange in your colleague, sir. They have not
Okay,
contested.
the other respondents are duly represented. So taking this court, also having taken note of that the LCRs have been received, lists the matter for hearing in its usual court.
Earlier.
Contempt case. RSC to contempt. Because RSC क्यों हुआ? Yes, why there is a RSA?
But RSA is dismissed for default, and we have filed a restoration petition.
You are for whom?
I'm for respondent.
Why you are filing a restoration of an RSA?
But in RSA, we are applying.
And the contempt is for what?
Contempt to opposite party, madam.
Huh?
In contempt, we are opposite party. They say that some status quo order was passed by your lordship, and that was violated my client.
Status quo order. Violation. This is an application under section 11 and 12 of the Contempt of Court Act 1971. Seeking to bring to the attention of this court that the order dated 6/1/2020 as well as the order dated 6/1/2010 as well as the order dated 12/11/2010 wherein there was a direction to maintain status quo with regard to possession of the decreed land have been violated. This court finds it relevant to mention, observe that the petitioner herein is not represented. And in absence of the petitioner, it would be difficult to discern as to whether there has been any violation to the status quo order. On the other hand, Mr. M.A. Sheikh, the learned counsel appearing on behalf of the respondent in the instant proceeding, submits that there is no violation. The said aspect, therefore, would require an adjudication as regards the facts as to whether there has been a violation to the status quo order. Taking into account that none has appeared on behalf of the petitioner, and these aspects cannot be adjudicated, this court dismisses the instant application. And this court drops the instant proceedings against the respondent. The contempt proceedings accordingly stands closed.
Right.
Yes, LCR has been received. Yes.
Actually, I could not find the correct address of the respondent. I have tried several substitute manner of paper.
The record reveals that a LCR has been received. However, the service upon the respondent is not complete. Why do you need the other respondent? Why are the other respondents required?
Other respondents are responded for deputy.
So Deputy Commissioner is Madam.
Yes, earlier I have sent this notice, but the respond landowner.
He'll be appearing.
Copy may be typed to ask.
He'll have. Then others, why do you need others? Here, this is only a question of inadequacy of compensation, not on the question of apportionment. Yes, tell me. The judgment is only on inadequacy of compensation. Then
the applicant did the reference. So,
what?
And the judgment, there is no any direct case is in the NFL. So kindly wanted
to whom? To the trial court.
Yes.
Why?
Because the evidence
Acquisition for what?
In the reference.
Acquisition for what?
for railway BG line construction.
For construction of BG line. You want setting aside of the award in your favor, which is already in your favor. Oh, appeal is by Northeast Railway. You are the NF Railway. You have filed an appeal because you were not a party.
Yes.
And we have not been able to serve against these people.
Yes.
Okay. Then how long do you want to keep this appeal pending? Then give a paper publication in these areas. Give a paper publication. They will know they have to pay the money. Then why you are not taking steps to that effect? What steps? This type of step won't happen. Are you aware that this appeal was filed in 2008? The compensation at that time was 3,000 per bigha. Now, we are in 2024 and service is not complete. We should dismiss the appeal. You go to Supreme Court. Supreme Court may help you out. Better off. You have not been able to serve. What is wrong with the order? Only ground is that you were not made a party. That's your only ground. You can't file an appeal like this. The collector was there very much as regards the compensation. Leads the matter. Please, this matter. This court have duly taken note of that the office LCR has been received. However, the service upon the claimants have not, upon the respondents have not been effected till date. This court fixes this matter on 27th of May 2024. The learned counsel appearing on behalf of the appellant shall apprise this court as to whether the decretal amount as passed by the decretal amount as passed in the order dated judgment dated 10/1/1997 in the various reference cases against which the instant batch of appeals have been filed have been duly paid, deposited with the district commissioner. With the collector. Dokhin Rani will be where? Kamrup Metro, na?
Kamrup.
With the collector. With the performer respondent. Get your instructions. It can't remain like. Have you deposited it or not? We close this. These are the appeals. Railways are have to finish something. Yes, what is it?
What you the last provision was asked me to collect your acceptance.
Oh, yes, yes.
What you accordingly have put it.
What is it?
I have.
What is the address?
in Surod itself, but I got the name of the path.
Eh?
Surojit Gogoi Path. Surojit Gogoi Path, Surod Kitnet. House number 30.
How did you contact him?
I got the phone number from the phone. I had had a telephonic conversation with the legal heirs of the appellant.
Appellant died.
Appellant expired
When?
on 15/11/20.
Huh?
Year 2020. I informed the court in the on 15/11/2020.
You have informed?
Yes.
No steps have been taken
After that, no steps have been taken. We have
for legal heirs. No steps
no, we
taken.
have called them up and asked them whether they are inclined to carry on with the matter, but they are not really inclined to carry on with the matter.
Hello. Your name, madam? Ms. S. Musahari, the learned counsel appearing on behalf of the respondent, submits that in the order dated 15/11/2022, it has been duly mentioned that the appellant had expired and thereupon no steps have been taken. Mr. Edeka, the learned counsel, who was asked to inform this court as regards the address of the appellant, also submitted that the appellant had expired in the year 2022. So, taking into account the above, as no steps have been taken for substitution of the legal representatives, the instant appeal stands abated and accordingly stands closed. The LCR, the registry shall forthwith return the LCR to the court. I to technically in view of the abatement of the appeal, nothing. This court, by an order dated, none appears on behalf of the applicant. This court, by an order dated 8/10/2015, had directed the applicant to file an application for condonation of delay. However, no such application has been filed for almost 9 years. Considering the above, this court holds that the instant application so filed is barred by limitation for which the same cannot be entertained. Accordingly, the instant application stands dismissed.
Obliged.
Yes.
This is my lord, the appeal is my lord, the default my lord. And accordingly, my lord, we have filed the application for response along with condonation of delay, my lord. While serving notice, my lord, we came to know that reference number 1 he died. Accordingly, we have filed the application for service along with the condonation of delay.
When?
In separately for 1 to 3. And my lord, so far the condonation of delay application is concerned, my lord. Yes, my lord, has allowed yes, condone.
When?
Yes, lord.
IA number?
IA number 734, 752, and 735.
Then?
And he, my lord,
what about 3C?
Yes, my lord. That 3C, my lord, we have already filed that there is an office, my lord, that it has been reflected that it has not found, my lord.
Huh?
Office note dated 34/20/24, my lord.
Hmm.
But I, my lord,
CC has also expired.
Yes, my lord.
Then
And we have, my lord, filed applications, my lord, and I have, my lord, serial number. I will track it, my lord, but I did not collect them.
the land council appearing on behalf of the applicant submits that in view of the office note showing that respondent number 3C had expired, further applications have been filed. However, the same are not on record. List the matter. Yes, what is
On
this?
last occasion, I was directed to inform the applicant about the case, my lord. Since the counsel for the applicant, the application was passed, I was directed to inform the counsel of the applicant as well as the registered for the applicant.
What is this I for?
Before condemnation of the I am for the respondent.
Why they are not appearing?
The Mr. has passed away. And
That is long time back.
My lord, and accordingly, this court directed me to inform the counsel, the other counsel, as well as give a representation to the applicant. I have given it on 4/500. Maybe.
None has appeared on behalf of the applicant on call.
As per the direction of the court, I have sent a letter to the applicant. The applicant as well.
Why you are going to do all these things?
Well, because the court has directed me.
None has appeared on behalf of the applicant on call. Mr. M. Smith appears on behalf of the respondent number 1 and 2. Taking into account that none has appeared on behalf of the applicant on the earlier occasions also, this court is of the opinion that the applicant have lost interest in the instant proceedings for which the instant application stands dismissed for non-profit. In view of the above, the accompanying miscellaneous first appeal cannot be entertained being barred by limit. Yes.
Lordship, this office note dated P5/24 detects that in compliance with the order passed by the Honorable Court, the HT has had the notice from the source respondent, but no color Sama has been filed.
Who is appearing for the applicant? Why is this IA file?
IA is for condemnation of detail.
This court have duly taken note of the office note dated 3/5/2024. List the matter on 19th of June 2024, on which date the registry shall give an update as to whether the notice sent to the respondent have been duly communicated.
May submit.
Yes.
Since they are not interested in that,
Understood.
detail may be confirmed, and this matter may be decided on May.
You see, when there is an order passed by the court to send a notice, we can do it. One thing, let this be on 29th May. Good. Huh? Yes, service complete.
Yes.
Service complete. Then what is this CRP for?
Because
what are you challenging?
if the suit was for default under Order 9 Rule 5.
Order 9?
And Order 9 Rule 5. Rule 5, which does not provide any remedy for restoration.
Why was it dismissed?
because they have not taken steps within 7 days from the date of order of the court. After the return, someone was returned after.
And
Then this was dismissed for default. And later on, they have filed an application under Order 9 for restoration of truth. That was allowed against the fact. Because Order 9 rule.
for taking steps.
Below?
For taking steps.
Yes, yes. Order 9 rule.
Order 9, Rule 9, they file where?
They are in.
Trial court.
Right.
And against that, an appeal lies under where? Order 9, Rule 9. Where does an appeal lie?
No, Miller. It's taking.
Order 9, Rule 9, Order 43, Rule 1C. Isn't it?
Yes, Miller.
Then why should we entertain under 150?
Because it is not maintainable at all.
Huh?
Not maintainable at all.
I don't find anything. You want it on merit? Dismiss it. This high step. This has to be dismissed. Some steps were not taken. Those steps have been corrected. In fact, the claims also have been rejected. Under Order 9, Rule 7, Order 9, Rule 8.
But Miller, court has invoked Section 151.
Whatever they, the order is right. 151, then okay, let me hold it rightly done.
Because special provision is there. Because court has.
Then this type of orders,
Otherwise, Miller.
There's nothing. Let us do it right.
May I read that portion because
what?
The remedy against Order 9 Rule 5. Remedy against Order 9 Rule 5.
What is it?
Miller. Has to be filed. Specifically, it is provided. Rule 2, in such case, plaintiff may, subject to the law of limitation being a fresh specific provision. Rule 2.
It is an application. 115.
100
of the Code of Civil Procedure 1908 for short the court challenging the order dated 8/12/2021, whereby the learned court of the civil judge number 1 Qatar Silchar had restored the suit by allowing the miscellaneous case being J case number 89 of the 2019. I've heard Mr. S.K. Sahu, the learned counsel, appearing on behalf of the petitioner, and Mr. C. Gogoi appearing on behalf of the respondent. The learned counsel appearing on behalf of the petitioner submit that when an application is filed, when a suit is dismissed in terms with Order 9, Rule 5, the recourse available is to file a suit, press suit, that too within the period of limitation in terms with Order 9, Rule 5, bracket 2. He therefore submitted that the application so filed by the plaintiff for restoration of the suit was not at all maintainable, and accordingly the learned trial court had committed jurisdictional error in passing the order dated 8/12/2021. On the other hand, the learned counsel appearing on behalf of the respondent, Mr. T. Gogoi, submitted that the application may have been filed under Order 9, Rule 9 for restoration of the suit. But the fact remains that Order 9, Rule 5 was not at all applicable, taking into account that it has been categorically mentioned in the impugned order that on 11/3/2019, the summons were duly served upon the defendant. The learned counsel submitted that Order 9, Rule 5 would have only had an application if the service summons upon the defendants have returned unserved. The learned counsel, further expanding his argument, submitted that in the instant case, it is a mistake being committed by the court which has caused prejudice to the plaintiff. And as such, the court was justified to recall the order. And this power is engraved in the court under Section 151 to do complete justice. This court,
kindly come to page.
This court, having taken note of enough, this court have perused the impugned order dated 18/12/2021. And from the impugned order, it is seen that it is categorically mentioned that the summons was served upon the defendant on 11/3/2019. It was also mentioned that the service report given by the process server was specific as to when that as the defendant was not found in his residence, summons was served upon one of her adult male family members sharing the same mess. taking into account that in the said suit, there was only one defendant. And the summons to served on 11/3/2019. The order dated 8/8/2019 could not have been passed by the learned trial court. By could not have been passed by the learned trial in exercise of the powers under Order 9, Rule 5 of the Code. This court have duly taken note of the learned trial court by the impugned order dated 8/12/2021 have duly accepted that it was a mistake on the part of the trial court in passing the order, and accordingly had recalled the state order. And this court, in exercise of the powers under Section 115 of the Code, does not find any jurisdictional error in the order dated 8/12/2021, for which the instant petition stands dismissed. This court further, there is no stay.
No,
What is the stage of the suit?
it is not on SR. Because after disposal of the suit, press notice was
This court duly takes note of that the petitioner now is aware of the suit being pending. And as such, the petitioner shall directed to appear before the learned trial court on 11/6/2024. On which date the parties herein, who are the plaintiff and the both defendants, shall appear before the learned trial court on 18/6/2020.
their process server was guided by plaintiff. Their petition itself they have accepted.
You have taken already 3 years. Not 3 years. 2019 till 2005 years. You have already finished the plaintiff's case. Yes, Mr. Bok.
29(1) is the service to respondent number.
No step received by the section for respond number 2.
Actually, I have stopped it on the government aspect, my lord, but I have lost the copy. I'll take first step, my lord. Both of them. One is
Respond number 2 is Secretary Land Revenue.
Revenue Department.
Then why you are not serving? Who is appearing for respond number 1?
One, my lord, it has come back answer, my lord. I take first step.
It is insufficient address. This court, by an order dated 25/3/2022, had issued notice. What is that order? Which order?
Well, notice was
Which order?
my lord, 25/3/22.
Eviction.
My lord.
Section 9.
My lord.
Appeal. Was set aside.
Actually,
Appeal is allowed, however, without cause. The impugned order passed by AI is set aside and referred. What is the ground?
My lord, in fact, this order was passed on assumptions, my lord. There was another title suit was filed for some other purpose, my lord. So the this is just come to a conclusion that since that this land also is nearby, it is a Sarkari land and not a railway land.
But the land document submitted by the railway is my lord. The whole land plan is there. The date will have. Customer is note of a report.
The government reserve land.
But is the railway list, my lord, that I have the map, my lord, then I have attached with that.
Your map, railway map is very
In
difficult.
fact, my lord, the report was also
They go
submitted.
by two things. One is this railway map, and the second is you have your own paper, na, by
Land
which you, huh?
Land plan.
Land, which has nothing to do with that. And the government records it as there. The main thing is for the revenue to stay out there as to whether it is. Anyway, it reveals from the records that the service upon both the respondents are not complete. The petitioner is directed to take steps upon the respondent number 1 by way of registered as well as usual within 7 days from today. As regards the respondent number 2, the petitioner is directed to serve a copy of the instant petition to Mr. R. Borputari, the Learned Scanning Council of the Revenue, within 7 days from today. List the matter after completion of service. None appears on behalf of the applicant or false. It is also seen that no substitution application has been filed insofar as the respondent number 2. This court, for the end of justice, adjourns the matter to be listed again on 27th of May 2024. It is made clear if the applicant is not represented on the next date, the instant application shall be dismissed or not. Yes, what is this?
As per office to aspect of number 8 and 11 created are
8 and 11. And
both
not been. List the matter.
my lord, both this text of the page. Both this. Both it shows that they appear on behalf of all the rest. Inadvertently, my lord, but we have filed wakalat number.
For others, not 8 and 11.
Yes. Inadvertently.
From the records, it reveals that the service upon the respondent number 8 and 11 is not complete. List the matter. You want to take fresh steps?
My lord, both same family, my lord.
Same family?
Same family, my lord. No, my lord.
What is this same family business?
My lord, kindly see 8, my lord. Is residing in the
8 is Mosudar
Ali.
Ali.
My lord,
9 is both.
9, 10. Mosudar Ali. Son, daughter.
Oh, you are not accepting for your mother. 10 is the son. You are appearing, but not for the mother. Don't come up with all these silly excuses. And the other is the brother. 2 brothers you are appearing, and 1 brother you are not appearing, and 11 the mother, your mother you are not appearing. You are putting your mother out there that she is not represented. It's not done. Get your instructions. Don't come up with all this plea before this court. Next week, get your instructions, whatever may be. File your wakalatam. List the matter again on taking into account that the respondent account, Mr. What's your name?
Eke Hanna. Eke Hanna.
When The learned counsel duly represents the respondent number 1 to 7, 9, 10, 12 to 14 by filing wakalatnama. And the respondent number 8 and 11 are related to the respondent number 9 and 10. The learned counsel appearing on behalf of the said respondent submits that he will take instruction as to whether he would be appearing on behalf of the said respondents. List the matter again on 25/2024 for an update. Get your file, your wakalatnama.
My lord, in this case, as per office note dated 2/5/24.
44.
2/5. 2 May 2024.
You are appearing for whom?
I'm appearing for 1 to 5. But the services has not been completed upon the respondent number 6A to 6B and 7A to 7C.
None appears on behalf of the applicant on call, appellant on call. It further appears that no steps have been received in respect of performer respondent number 6A to 6B and 7A to 7C. This court fixes the matter on 25/2024. If the appellant does not take steps, this court would construe that the appellant does not want to proceed against the performer respondent and shall proceed with the suit appeal accordingly. Yes, 1C expired. Mr. B.K. Das, the learned counsel appearing on behalf of the appellant submits that you would like to take appropriate steps in respect to the respondent number 1C. Matters then adjourned to be listed after 2 weeks. Okay.
It is just by last directed to keep file WS but honorable court. But I am unable to appear before that to expire my father.
Huh?
It expire my father, I am unable to appear before the last.
Yes, then you file your WS.
I am not able to appear, loss of the father expired. On 18/4 he expired.
Your father or the client's father?
Client father.
Then
service completed other part. There is no stay order.
they too have vacated.
No.
Okay. The office note shows that the respondent is duly represented by filing a wakalatnama. However, none has appeared on behalf of the respondent. List the matter again on 15/5/2024. It is made clear if the respondent is not represented, the court shall proceed with the instant proceeding in his absence. It has also been mentioned by the learned counsel appearing on behalf of the petitioner that the father of the petitioner had expired, and as such, the written statement could not be filed. This issue would be duly taken note of on the next date. Yes. What is this? Review. What have I done wrong?
Here, my lord, kindly have a look. Page 25 of the judgment.
Page
25.
What have I done? My judgment.
Here, my lord, one notification was taken on board, my lord, but this notification
Page
is
25.
page 25. My lord,
yes.
on the bottom, my lord, second paragraph, my lord. His age of retirement of grade 4 employee and other state government employee who are at present entitled to serve up to the age of 60 years, including the new entrant, will continue to be 60 years.
Yes.
That was not taken.
Huh?
That was not taken into consideration, my lord.
Why?
Now, Lordship, kindly have a look.
In the age of termination of the petitioner number 1 to write if the benefit of the is not given, the date of retirement of the if the benefit of the petitioner is given which is otherwise not applicable, then also the age of termination of the Section 8 of the Act of duty applies to the would be deemed to have retired prior to 5, and accordingly they would only be entitled to annuity, pension, or family care if under 9. Then what is wrong?
Now, my lord, paragraph 27, page 26.
Huh?
Paragraph, my lord, 27, page 26.
Yes, that is what I read.
Yes. Here, my lord, because
I say that if there is a first, it is not applicable. Even if it is applicable also, you tend to retire on 36/2004, 31/8/2004, 31/8/2004, 39/2004, and 31/10/2010. And as such, you do not come under the ambit of Section 8 of the Iman. And under such circumstances, you would be deemed to have retired prior to 1/1/2005.
yes, sir. Now, Lordship, kindly will look page 6, paragraph 6.
Yeah?
Paragraph 6, one.
6?
Paragraph.
Why should I go behind?
Because here, my lord, they were, my lord, made government employee from their inception, my lord. Paragraph 6, my lord.
Right, prior to 1/1/2005 not be entitled to this would yes.
Now, my lord, shall be deemed to have been become the employee of the government, and on the from the date on which the college have been brought under the deficit system of grant in it on the terms and conditions mentioned in section 3 of the Act of 2005. So they are already government employee, my lord, as per section 3 from the inception of their service, my lord.
Where?
Paragraph, my lord, 6. Page 16, my lord.
Employee who has retired on attaining the age of superannuation or of their age to then
मैं kindly peruse paragraph 4. Paragraph
4.
Paragraph 4 का page 15.
8.
My lord has rightly considered Lordship. Page 15, Lordship.
15.
1/5, Lordship. 1/5. Paragraph 4, Lordship has kindly peruse, and then Lordship may paragraph 27. Lordship. Then my lord may kindly come to paragraph 27. Lordship has rightly considered everything, Lordship, the statutory provision as well as OM. Paragraph 27. Page 26. Lord.
Yes, we have filed appeal. What?
What provision was taken out of the
No. These are questions of appeal.
only, my lord, this conclusion, my lord, because we are already, my lord, as is, my lord, taking note of, my lord, section 3, create with my lord this notification. My lord, they are in my lord category of 60
I
years.
have duly considered it properly there.
Only my lord, I have found my lord that
It has to be error apparent on the face of the record, and if it had taken 4 minutes for this court to find out and not find anything,
exactly
means it is a case of no error. It is a case of appeal.
This kind of appeal or this kind of review or may dismiss with cost work. With cost work, this kind of review.
How much?
Yes,
Today I have not imposed a cost.
Even
So
1 rupee also.
now my AR, I put a particular figure. Figure is something like this. 1 lakh per day. Yes. Today, whole day I have not imposed any cost.
Then
So I always distribute it. Some are 25, 30, like this, I put it one. So today, in the entire day, there has been no cost. So the entire burden has to fall upon him.
I'm not saying that. Otherwise, Lordship may impose cost.
No, the entire burden has to fall upon
Abuse of the process of law and Lordship, they have
abuse of the
process of law and judicial.
No, I know the reason why you have filed, Mr. Porter. You want to take care of the limitation out there. We filed a review and the review has been dismissed, and as such, now I have come. So your basic idea is that you want to go and file an appeal and in order to take care of this.
only my lord, I have fairly submitted. My lord,
Huh?
I have found my lord that their my lord service was made government employee for the exception of their service. That point was not perhaps my lord the lordship did not my lord see. Therefore, my lord,
They were government servants.
yes, my lord, because as far
Where you appointed against sanction force.
my lord, this is earlier my this is not dispute my lord because they are
No, that is the only question. Where you appointed against sanction force.
take instruction my lord because that
What seek instruction? That is the question.
File review Lordship now he's taking it.
You want the, and you have not taken. That is the basic idea. You have to be appointed against the sanction force. If you are appointed, then it is okay. Then only the TD will come.
that what my lord pension they are not getting my lord paid.
Pension, there is no quarrel. You are not going to get a pension. You may get a pension. But the question is how, because whether you will come under to get the leave encashment, that is the issue which was involved.
And 2C also, Lordship, he or she should be the Lordship existing employee.
Hmm?
As per section 2C, Lordship, he or she should be the existing employee. On or after Lordship,
5 numbers.
Lord, 1/2005.
In fact, what submission you are making, I have also taken, then let us assume that 2 years is also being given.
No.
Then also you don't get the benefit.
Lordship.
1 year given my lord I am.
1 year, 2 years, whatever maybe if it is given, then also you don't get the benefit in your paragraph 27.
Paragraph 27 as well as paragraph 4. Lordship. Paragraph 4 read with paragraph 27.
May I clarify my lord? As per this
You don't qualify, get your instructions because today 1 lakh is the cost.
my lord.
You want to take the risk, take the risk. Take the risk.
Another day my lord.
It will be lesser, Lordship.
Eh?
Another day it will be lesser.
Yes, come on a day when I am on Monday, Wednesday, Thursday. Today is Monday, a lot of people didn't turn up. That is why I could not. On other days, you may get it up.
Only my lord, they are not. If it is said that my lord, those who are in the category of 60 years, like us, my lord, we will continue as 60 years. But your lordship held that my lord.
That is why I said, even if we give the benefit also, you don't come within it. That is paragraph 27.
1 year benefit. My lord.
Okay. So what to do? I still have time.
Another day my lord.
And then don't spoil the time. The request of Mr. A.M. Borbuya matters transition instead of on after 2 weeks. Yes. What is this? Delay?
Oh my God, there is no delay.
What is this I for?
The appellant testament.
Huh?
The appellant, due to death of appellant, his legal heirs have filed this petition under Order 22, Rule 3 to substitute them as.
Why there is an objection file?
I do not know why they have filed objection.
Right
There
to
is
sue
no
does not
legal-
survive it. The right to sue does not survive in this case.
Oh.
Because he was the executor of the will, you're talking. And the will was not
Executor of the
probate.
Then
Probate was not.
what right? Can the executor of the will have any right? It may be a case of assignment. Whoever else is the executor of the will take over. You have no business of.
And that then hearing may take. In this regard, then hearing may take place.
Hearing done. What else to hear? Right to sue, how can it survive?
Otherwise, my lord, the properties which have been bequeathed, it is under our occupation till today.
That is a different aspect of the matter. We are not on that. You file the appeal as an executor in the capacity of an executor or on the basis of you are in possession. As an executor.
Yes.
If an executor died, the will has to say that after the person had died, the person, his son would become the executor.
I think we are also the representative within this definition of this executor.
How?
Because that is to that respect, let the hearing take place. Today only, I had never think that they will raise any objection in substituting a legal aid.
No, they would, because here it doesn't arise.
Yes, I.
Because there is a executor cannot be.
Executor is there. So even
Okay.
that a hearing take
You got a copy of the affidavit. You said no, you have not received objection.
No, we have got. We have got. But their substance is only that they cannot execute the will. That is the only question. Other, no legal provision has been shown by them.
No. If there is a will, if the executor expires, then there is a particular method by which you can appoint another one. What is the name?
Letters of administration.
Letter of administration. It has to go by a letter of administration. So it has to be done by a letter of administration if the executor is not there. And the court has to appoint in terms with the Indian succession. Okay, at the request of the Land Council, appearing on behalf of the parties, matters can be listed after 2 weeks. First time. I
am
first time. Issue notice. Returnable 4 weeks steps within 3 days. First time?
Yes.
Same order. 52, 53, same.
52 same.
53 also same. First time. First time. No. First notice has to go.
Apply.
Okay, give me 62. Yes, 62. Registry has checked and verified that the second appeal reportedly filed on 12 and bearing is lying defective in the filing section. On a further look at the case status at the High Court, it is found that the contents of the petition are not clear, sharp, and legible. A printout has been given and placed in the page with the mark text. Mr. Counsel, how can you file 2 appeals? How is it possible? The appeal is there.
Lord, that
Filing
appeal was abated.
Understood.
2015 it was abated. Second appeal filed in 2019.
Understood. RSA number 253896/2015. It came up before this court on 2 dates.
So that of number is my lord, date is defective, my lord.
Huh?
Date is not tally because 2009 date has been showing. Different date.
What?
Kindly see date.
2009.
Nine, not 2000, because it was filing 2015. How 2009 will come?
And it is lying defective. Contents of the petition and the accompanying documents are not clear, sharp, legible. Then how is this second appeal maintainable? Huh? How can you file 2 second appeals? And did you mention it in your first application? Huh?
I picked from that person. Proper the care I have new property that I have. So first I will file lordship, he could not come lordship. Then while I come to contact with the lordship, then lordship I have to I have only
No, if that appeal has already been filed
right.
by Ali Akbar,
Ali
it was defective. Whatever may be, that appeal you need to do whatever necessary. You can't file this one.
But disable file after the senior council lordship, there is also senior another senior council lordship by E. Banerjee.
So what?
He is ideal lordship. I have no mass ideal lordship.
How can you file a second one?
He said lordship in
If that person has already died, you can't file a second one. Then you need to make the necessary amendment to that and make it clear that we have filed it on so and so. Now these parties will change, remove the defects, bring it before the court, and say that this person has in the meantime died. So this is what it is. That can be done or whatever may be. But you cannot go ahead with this one.
My third test lordship that when the case is defective, so it cannot be treated as a case. And in the meantime, if somebody dies, so this case can be filed to impeding the all legal there.
What?
Impeding the this is the question of a child.
What does it say? Let us also get learned enough.
What is the legal issue in this regard? That's all the brief was given to him, Lord. And the substantial question of everything is prepared by him, Lord. That's why he said, I do not know whether this was.
No, you are the appellant's counsel. So under such circumstances, when you have already filed an appeal, kept it defective out there. So all these while, you have kept it defective.
Yep.
And then you filed this in 2019.
19.
And that appeal was filed in 2015.
During pendency of that appeal, appellant died. Not that prior to filing. After filing.
After filing, he died. So under such circumstances,
he never came back.
so what? So what? This appeal is not maintainable.
Again, lordship, I am my subsidiary. I have to take a question of any senior counsel.
Huh?
Because I have also my own knowledge of immediately in this field. Lordship.
You want whom? That day you said about senior counsel, I asked Mr. Dilip Majumdar in the court.
Now later on,
Obviously he will refuse when you make a false statement before this court. You said that you have already briefed him and he is not ready. Then when the matter came up and I asked him, why do you take so much? He said, no, he has not briefed me. He said he is going to come on Saturday to brief. You were there, no, Mr. Ghosh? In another matter. Don't come up with all these things. Now tell me how much. Oh, today I have not imposed any cost. 1 lakh is on you, the lawyer, making false statements.
Lordship, can it be any other day, Lordship?
We will keep it, your bar council registration in abeyance till you deposit this 1 lakh. That is the one.
The main thing is guided by an senior counsel.
No, forget about senior counsel. I'm not bothered with senior counsel. The question is you. For you, forget about the lawyer and the client. Now you save yourself. How do you save?
No, this case was filed, Lordship. This case was filed, Lordship, under the guidance of
You knew it when the application was filed out here that there was another appeal filed.
He knows, Lordship. He knows.
So then, how could you file the second appeal?
Third says that yes, that can be, Lordship.
What?
He says that yes, it can be, and it can be that
Who says?
by penalty, sir, Lordship. Penalty.
So how, if he says that is the law?
Says, Lordship, some,
No, if he says that is the law,
some judgment is there, Lordship.
so show me the judgment.
Yes, sir, Lordship. He is not.
Show me the judgment. Because if we are to consider your submission that a defective appeal filed cannot be considered as filing, it should have far-reaching consequences in all appeals filed.
That Lordship told me that.
No, if you hold it,
And I'll try to establish this point.
no, if you do it, I will be very happy
Yes, I'll study, Lordship.
if you do that. Because why? What will happen? That all appeals which have been filed and kept defective, all will be barred by limitation. Not this. All appeals will be barred by limitation. See the repercussions which you are making the submission. All appeals, whoever has filed. Just for example, there is a defect being caught by the office. It will be barred by limitation.
It's all very limited here, Lordship. Actually,
No, don't come up with limited knowledge.
yes, Lordship.
You have the limited knowledge on your bank statement as to deposit the amount of 1 lakh as cost. That is the limited knowledge you should take. Don't come up with all. Anyway, this court have duly taken note of the office note dated 4/5/2024. List the matter again on 15/5/2024. At the top of the list, along with the records of the appeal filed on 25/5/2015 bearing serial number 253896, if any. Yes, what is this?
Lordship, in this case, what happened? The respondent number 3 was appointed as a guardian, my Lordship. But the thing is that, as per the order dated, my Lordship,
Yes, you are the mother.
no, I am the daughter.
I understand. You were then not there, but 18 years was then when you filed the appeal.
Yes, but what happened, my Lordship, the mother has concealed certain facts. He did not show that he was a government employee, plus he's getting the pension of my father and bank balance of my father was there.
He or she?
She. He
Ah,
was
she,
government.
then?
He was a government employee. Plus, also that he was getting the pension of my father. My father was also government employee. Plus, the bank balance of my father was also there. Despite having all these things were concealed before the court, honorable court, while for appointing as a guardianship, they have concealed certain things.
Where are you staying with your parents?
Hmm?
Where are you staying with your mother?
Right now, I'm not staying with my mother.
Where are you staying with your mother at that point of time?
Yes, my. Yes.
Then?
Staying with my mother, my Lordship. But these are the facts were being not shown to the court.
So what?
They misled it, and my mother was appointed.
Then why haven't you challenged the sale deed?
Yes, my lord. This title suit was filed, and title suit was filed jointly by mother and daughter, my lord.
Something is there. Therefore, I knew it. Something is wrong. Because what you want to do is that you and your mother now want to escape the sale deed.
Yes.
And therefore want to set aside this order. And if this is set aside, then entire thing goes.
Yes, my lord. There is a nexus, my lord.
Yeah. Yes. A suit for cancellation of the sale deed for the land measuring 3 because so and so, so and so.
And entire dispute is with me, my lord, because land was sold to me, my lord. Registration was
Ah, yes. And when was the suit filed?
Actually, my lordship, that respondent number 456 is to, after my death of my father, respondent number 456 to keep all the, all the, documents with them. They used to.
Who is Abdus Kudus Borbhuya? Your brother. All of you have now filed a challenge the suit.
Because we don't know that time, my lord.
Then?
The expertise order was passed.
What expert don't know?
In the guardianship that.
Then, therefore you allege that your mother had made a false statement. You do one thing. You file this, bring a certified copy on this and file an objection to this application. Huh? We will dismiss it with cause. And say that the reason why they are filing it now after 651 days, knowing it fully well. And when did they file it? 21. And when did the order was passed?
2018, my lord.
2018. And that means 2018, these people were also minors.
Yes, my lord.
Number two.
Number two.
Number 2, 3, and 4
yes.
are minors.
Yes, my lord. He obtained the guardianship certificate, my lord. Then he sold the land to me, my lord. I developed the land, my lord. I constructed my dwelling house. Then, my lord.
You bring that. 1 week time. 1 week time you bring in. So we dismiss this without this. You just mention why they have filed. This is a fraud being committed on this. We'll take it. List the matter again on Mr.
A.H.M.R. Chaudhary.
A.H.M.R. Chaudhary, the learned counsel appearing on behalf of the respondent, submits that he, respondent number 1.
Respondent number 4, my proforma respondent.
Proforma now?
Yes, my
and my mother is the main?
Yes, my friend.
Appearing on behalf of the respondent number 2, submit that this is an application, is the instant appeal as well as the application so far is nothing but a ploy to set aside a sale deed for which a separate suit have been already filed. So he submits that he may be permitted to file an objection to the instant application. So list the matter again on 27/5/2024. So in the meantime, the application be filed by the objection be filed by 22nd of May with advance copy to the public. What is this, IA?
My lord, the matter has been my lord, compromised between the parties, my lord.
Huh?
Matter has been compromised between the parties, my lord.
Fantastic.
And compromise agreement has been, my lord.
Compromise done.
My lord. And they, my lord,
so you want to do one though? Withdraw?
No, my lord, the STC, my lord, as per compromise agreement, my lord, they will deposit the amount before the registry of this honorable court, my lord.
You file an application, a joint affidavit?
agreement, my lord.
Both of you file a joint affidavit. I can't take it like this.
Yes.
It has been submitted at the part that the matter have been already compromised among the parties. And as such, they want to, the councils submit that they would file a joint affidavit in that regard by bringing on record the state compromise. List the matter again on 27.5. 27.5. File, you only have to file that up.
Strike out the name of the respondent number 1. It was expired.
Strike out.
Okay. The respondents are here.
Who expired?
Bornali Das.
Bornali?
Das.
She expired?
Expired.
You have no objection? Okay, this is an application for striking out the name of the respondent number, appellant number 1.
Respondent. Because
Respondent number 1. Respondent number 1.
Yes.
Respondent number 1. Where is the respondent number 1?
In me.
It is his appeal.
Yes.
My appeal. Who has filed that application?
I have filed.
Who are you to ask for striking up?
I am the representing mother-in-law and son.
Mother-in-law is who? Bornali Das.
Sorolada. She respondents are there.
And who is Bornali Das?
Bornali Das is the deceased wife. And Rishikesh Das is the son.
Death certificate you have enclosed?
Yes, death certificate and next of kin also there.
The instant application has been filed by the applicant who are the respondent number 1, 2, and respondent in the instant appeal, accompanying appeal. So it has been stated that the respondent number 1, who was the claimant number 1, had expired on
3/6/2019.
3/6/2019, and further submitted that the estate of the respondent number 1 is duly represented by the respondent number 2.
Respondent number 3, respondent 2 is my house.
What is the age of my
15 years.
When?
This next of kin is there.
Estate has to be represented by somebody.
This Sorolada is representing now.
Is represented by the respondent number 2. 3 cannot be, na? 3 cannot represent the estate because she is nowhere. When there is a class 1 heir, the class 1 heir is 2. Can the mother-in-law get in view of the son-in-law? No. Means that the estate of the respondent number 2, the estate of the respondent number 1 is duly represented by the respondent number 2. It has been also mentioned that the respondent number 2 is still a minor. However, he is still under the guardianship of the respondent number 3. So, taking into account the above, the name of the respondent number 1 is struck off. I stand allowed. The registry shall make necessary correction of the appellant. The counsel for the appellant, Mr. R. Batra, shall file an fresh memo of parties before the registry of the court by 10/5/2024. And on the basis thereof, the registry shall make necessary correction in the court side as well as all update the same in the CIS. I
between the parties, total local.
What?
Local or classification just speaks for local. Due to non-striking out the modality that it was not settled. If
you want to? But it is on 11.
11. Yes.
So you agree, both of you agree.
Okay,
We'll pass the decree.
only this order is needed.
The parties may very well would be at liberty to approach the legal service authority for placing the matter before the Lokatal if they so that.